Yes.
in today's list, Miller. Miller, I have been just engaged on behalf of the respondent Oil India.
Just engaged.
Yes, Miller. Just some accommodation for the day. I have already informed Mr. Mahanto, who is appearing for the petitioner.
Oil India. Item 10.
Item 10.
All right. Yes.
Subject to your lordship's convenience, Miller, if it can be taken up on 20th. Miller, they are suggesting that date.
It will have to go in April. Why not we call
On April 2nd, your lord.
second?
Second, the first. India.
April or April? April or April? Second to
First, second,
then we'll have it on 3rd April.
third. Okay.
Item number 10.
10.
At the request made by Mr. S. Bhatto, Senior Counsel, Gurudeep Bhatto, expressing his difficulties to address the court on behalf of the respondent. The matter has deferred. So, counsel for the petitioner, Mr. S. Gautam, does not object to the prayer made, but prays for a fixed date. Has agreed to by both counsel that the matter be listed for this is for hearing. Hearing on 3rd of April.
Deeply okay. Lordship, I beg to mention for listing of an arbitration petition in admission column, Lordship. Any date in next week, Lordship.
Next week.
Next week.
Next week, any date? That would be on 17th.
The item number 1, my lord, it comes into orders column, but last occasion there is an order to hear in admission column, my lord. So next Tuesday it is fixed as admission column, my lord, because
What difference does it make, orders or admission or hearing? If you want to go for the hearing, you get ready, we'll take it up.
today there is a
Say that. If you're not ready, you say that.
Yes.
Don't say
Yes,
that
yes.
it has come for admission orders.
Yes. That is
Item
No,
1
next
at the request of Mr. Purwa, MJ Purwa. Matter stands deferred to be listed after 1 week for admission. Yes.
Lordship permission, may I mention a batch of Section 11 arbitration petitions for appointment of arbitrator, where the pleadings are complete. Lordship, I'm requesting with the consent of the other side, if it can be fixed sometime in the end of March, Your Lordship.
End of March.
28th of March is something, a date that is convenient to both of us, subject to Your Lordship convenience, of course, if it can be fixed. It's a Section 11 for appointment. 28th of March.
28th.
Deeply obliged.
28th of March. You have to give a mention memo.
I will.
Yes.
Lord, I am seeking accommodation with regard to item number 5 to 8. My Lord, in these matters, my Lord, I have been engaged recently. Lord, I need to file wakalatnama. There are so many persons, my Lord. Few of them I can file. It will take at least 4 weeks time to file the thing.
Item 5 to 8, the request of Mr. H. Das, counsel appearing
H.K. Das.
petitioner, H.K. Das, who submits that he has been recently engaged in the matter and his instructions in the matters are not complete. He therefore prays for accommodation for 2 weeks.
3 weeks, my Lord.
3 weeks. Who's for the respondent?
CD.
Any objection?
I'll inform you.
Okay. Prayer made is not objected to by the counsel for the. Have you informed the other side? You did not inform the other side.
My
information was not given to us.
I-
RKD should will be appearing.
I beg apology.
I'll inform.
I'll inform, my Lord.
The matters
Ma'am,
then
I'm supposed to do
deferred
that.
to be listed after 3 weeks.
My-
3 weeks.
Yes. Highly obliged.
Lordship, in respect to item number 2, we pay both the side lordship any other day. Today some difficulties from both the end.
Item 2.
Item 2.
This is 2013 matter.
Otherwise, there is some difficulties today on our part.
All right, well, for the day, we can accommodate you for the day. Item 13, item 2
Item 2.
will not be called up today. That's all we can say.
For hearing, I think
May I please look? This writ petition is filed for the illegality appointing respondent number 4, Moromi Medi, for the post of lecturer of Kathak dance in the Government College of Music. During the pendency of this writ petition, respondent number 4 had voluntarily retired from the post. So this writ petition may become infractuous. Your Lordship. Yeah.
Mr.
And Thakuria for S, sir.
Mr. N. Thakuria appearing for Mr.
Yes, sir. Satyajit, sir.
Mr. H. Sharma submits that the writ petition has become infractuous as the challenge was made for the appointment of the private respondent by the state respondent, by respondents number 1, 2, and 3. Stop. During the pendency of the writ petition, the respondent number 4 submitted respondent number 4 took voluntary retirement in the matter. Accordingly, the petition has become infractuous. Writ petitioner does not wish to press for the claim. Writ petition accordingly dismissed, has not pressed, and interim orders, if any, stand vacated. Pending ayes are also dismissed. Mr. T.C. Tutia
1 and 2.
represents the respondents 1 and 2.
Hello.
Let's vote.
Item 4.
What is the age of superannuation of a Mondal?
65 down.
65.
65, my lord. Then it's a 14 meter. Yes. Job some Lat Mundal Lordship.
Yes.
Matter become infrastructure, I think.
Why?
Lordship, 4 additional Mondals were absorbed, Lordship.
Hmm.
2 was regular vacancy and 2 is a backlog vacancy for SC and SC, Lordship.
Where have you stated in the affidavit?
Lordship, through affidavit, para 7, Lordship. May I read, Lordship?
One minute.
Affidavit in opposition filed by respondent number 4, Lordship.
Respondent number
Para 7.
4. Para 7. Yes.
With regard to the statement made in paragraph 6 of the writ petition, the deponent does not admit anything which is contrary to the and inconsistent of the records of the case. The further beg to submit that earlier 4 additional mandates were absorbed, 2 against regular vacancy and 2 against backlog vacancy of SC in regular vacant post of Mondals under the establishment of the deponent in the light of the government instruction by number dated 24/2/9, Lordship. The government order, Lordship. And moreover, Lordship, para 9 is the more relevant, Lordship.
Para 9.
9, Lordship. That with regard to a statement made in paragraph 9 of the writ petition, deponent beg to submit that from the records available, additional Mondals under Dhubri district were absorbed against the regular vacant post of Lat Mondals under the establishment of the deponent as per seniority in gradation list, Lordship. Since the petitioner belongs to Kokrajhar district as such, in questions of which the absorptions under the Dhubri district does not arise, Lordship. So matter become infrastructure, Lord. Belongs to Kokrajhar district, Lordship, and it is absorbed in the regular seniority gradation list, Lordship.
None appears for the petitioner on call. Mr. A. Chakraborty, learned government advocate, represents the official respondent. Stop. This matter, petitioner has challenged. Has sought for a direction to absorb the petitioner as a lot mandal in the office of the Deputy Commissioner Deputy. In the posts of regular mandal lying vacant under the establishment of Deputy Commissioner Deputy. So, a notice in the matter was issued on 4/4/2014. Subsequently, rule was issued on 11/9/2014. Thereafter, the matter has been listed on several dates, but no hearing took place. On 27/2/2024, the matter was again listed. When the matter was listed, none had represented the petition. So today also, none represents the petition. Under such circumstances, this court is constrained to dismiss the present writ petition for non-prosecution. Pending interim orders, if any, will stand vacated. Pending ayes are also dismissed.
Obliged.
Item number 9.
Yeah, please, your lordship. Your lordship has heard this matter earlier occasion, your lordship. The matter relates to, we have put to challenge, your lordship, punishment imposed on the petitioner, your lordship. And what has happened, your lordship, facts in nutshell is like this, your lordship. There are 3 points I urge, your lordship, before this honorable court. First of all, your lordship, while passing the
impugn order, Your Lordship, the punishment, Your Lordship. The petitioner was, Your Lordship, not provided with a copy of the opinion of the Assam Public Service Commission, which is, Your Lordship, in violation of the law laid down by this honorable court, Your Lordship. And secondly, Your Lordship, my submission was, Your Lordship, that the admission on the basis of which the inquiry was, Your Lordship, completely do away with, Your Lordship. That admission was not unequivocal admission, Your Lordship. And thirdly, Your Lordship, I have placed one argument, Your Lordship, on the point of, Your Lordship, this after, Your Lordship, his punishment, he was not, Your Lordship, promoted to his next grade, Your Lordship. And on that point, Your Lordship, learned
Stoppage of one increment.
one increment, Your Lordship. And on that point, Your Lordship, my learned friend has, Your Lordship, not
Yes,
CPI, Your
they
Lordship.
placed two
Placed
judgments.
two judgments, Your Lordship. Now, on that point, Your Lordship, probably, Your Lordship, after going through that two judgments, I find that there is a specific provision for that in the rule itself, Your Lordship, Rule 157 of those rules, Your Lordship. So far as our rule is concerned, it is silent about that, Your Lordship. Apart from that, Your Lordship, I have tried to find out some other judgments also, but ultimately, Your Lordship, what my, as a officer of the court, Your Lordship, I have found, Your Lordship, law is well settled that yes, during currency of the punishment, Your Lordship, promotion cannot be granted even if rule does not provide for that, Your Lordship. That judgment is also I have found. Therefore, Your Lordship, probably it will not be correct for me to argue that point, Your
Give us the judgment.
Lordship. That I have. I'll get a point. That, Your Lordship, will be against me, Your Lordship. That's why I did not bring. I have one. I will hand over, Your Lordship.
But that would be necessary to
Lord, Lord.
here.
But the other 2 points, Your Lordship, more specifically point on which, Your Lordship, that this order is vitiated on the ground of non-furnishing of opinion of the government. That, Your Lordship, point I want. And if Your Lordship wants that judgment, Your Lordship may kindly give me 1 day time, Your Lordship. I will hand it over, Your Lordship.
No. Let us
Lordship.
see what was the other ground.
Lordship. Your Lordship will kindly see, Your Lordship, the petitioner, Your Lordship, he was in Borpeta, Your Lordship. He was transferred to Borpeta, Your Lordship, and he was transferred to Borpeta on 14/2/2011, Your Lordship. And he was, Your Lordship, he joined there on 21/2/2011. And he on 11/4/2012, he was entrusted with the charge of district mission coordinator of Sarva Shiksha Abhijan, Your Lordship, apart from his duty as an ADC, Your Lordship. And on 29/7/2013, he was transferred as Joint Secretary of the GovTech Assam Hills Area Department, Your Lordship. While he was serving as Joint Secretary of GovTech Assam Hills Area Development, Your Lordship, he was, Your Lordship, Your Lordship, SOCOS was issued on 21/2015. That is, Your Lordship, will get it at Annexer 9, Your Lordship, page 39, Your Lordship. Page 39. May I read, Your Lordship?
Yes.
Lord. You are hereby required to SOCOS under Rule 9 of Assam Service Discipline and Appeal Rules 1964, reviewed Article 311 of the Constitution of India. Why? Any of the pending prescribed in rule penalties prescribed in Rule 7 of the aforesaid rule should not be inflicted on you on the following charges based on statement of allegation attached herewith. That while you were holding the post of ADC cum District Mission Coordinator, Borpeta, you had transferred 220 numbers of teachers by sending SMS to their respective cell phone and verbal communication without obtaining any approval from the mission director, Sarva Shiksha Abhijan Mission. Further, you had also transferred another 70 numbers of teachers without obtaining any approval from the mission director of Sarva Shiksha Abhijan Assam, violating the norms of SSA. However, the Office of the Deputy Commissioner Borpeta recommended 6 proposals of changes of schools of posting of contractual teachers submitted by the District Mission Coordinator SSA Borpeta. The Deputy Commissioner recommended proposals to be submitted to the Mission Director SSA for approval. But you have effected some of the transfer by furnishing copies of the list of teachers approved and signed by the Deputy Commissioner, which was meant for submission to the Mission Director SSA for approval, keeping the district administration in dark, which amounts to violation of rules and regulations. Such activities can never be expected from any officer of your status and rank. You are therefore not only search for misleading the higher authority but also violation of Rule 3 of Assam Civil Service Conduct Rules 1965 and gross indiscipline. You should submit your written statement of defense within 10 days from the date of receipt communication, provided you do not intend to inspect the documents which have already relevance with the issues in inquiry. Now, Your Lordship, that is statement of allegation. Your Lordship will kindly come to page 43, Your Lordship, if you want. My reply, Your Lordship. First reply, Your Lordship. But here, Your Lordship will find para 4 is important, Your Lordship. That's why I am not reminiscent of transferring such a large number of teachers by sending SMS or through verbal communication without approval from Mission Director Sarva Shiksha Abhijan Mission, or by furnishing copies of the list of teachers approved and signed by Deputy Commissioner Borpeta as stated in the notice cited in reference above. I could only remember sending files for approval of the list of transfer proposal by Deputy Commissioner DMC office for taking following up actions, that is for forwarding the approved list of both in soft and hard copy of Mission Director Sarva Shiksha Abhijan District Program Officer and District Program Officer MIS as a normal office procedure. That's our I was not given an opportunity of being heard and deposed at the time of inquiry by Sri Ramendranath Sharma, ACS, Additional Deputy Commissioner and District Mission Coordinator, SSA Barbara, for reasons best known to him. Therefore, the report on the basis of which the charges is brought against me was perhaps prepared by so and so in assistance with DMC, SSA Barbara officials whose dubious role might not be totally ignored in the matter may kindly be considered incomplete, unilateral, and act of injustice done to me irrespective of this content. Under the above circle, I request the honor to kind enough to allow me to inspect the records, files, papers, documents, register relating to transfer of contractual teachers in Office of the Deputy Commissioner Borpeta, District Mission Coordinator SSA Borpeta, as well as other relevant documents on the basis of which statement of allegation is forwarded to me for submission of my written statement of defense. Then, Your Lordship, I was allowed to inspect, and then, Your Lordship, this created the problem. Page 45, Your Lordship, for me. This is my reply. Para 2, Your Lordship onwards. That, sir, I was not aware of the provision of contract between TET teachers and school managing committee of school. I also failed to understand why TET teachers followed verbal SMS transfer order of any other officer, including additional deputy commissioner DMC, in violation of their contract signed by them.
Para 4 is an admission.
Lordship, I will come to that, Your Lordship. DMC in violation of the contract signed by them with their respective SMS. It is not understood why the finance and accounts officer and district project officer Borpeta, in association with Block Mission Corps, have prepared the salary bills and placed before DMC SSA Borpeta and managed to get this bill countersigned, although they all knew that these were not valid transfers. But however, my counter signature of the bills did not cause any pecuniary loss to the government exchequer. As a part-time officer of SSA, I did not get sufficient time to go through the details of rule and procedure SSA, including those relating to transfer of posting of that teacher signing of contract if their payment, etc., because of my excessively overburdened duties and responsibilities as an additional deputy commissioner of district. I was not properly apprised regarding important circulars relating to TET teachers by the official of SSA Borpeta. That's why I never use mobiles and other officials of SSA Borpeta for sending transfer messages. Teachers, as some SSA Borpeta officials claim in their written statement, I may also claim that these officers might use my mobile phone for sending such SMS when I left behind the mobile inadvertently on my working table after my departure from the office. That's why, in spite of my sincere efforts, I failed to get full confidence of the officers and staff of SSA Borpeta. And on one occasion, I requested Deputy Commissioner to relieve me from the additional responsibility of District Mission Coordinator SSA Borpeta. The Mission Director SSA Assam also requested Deputy Commissioner to relieve me accordingly, but the Deputy Commissioner Borpeta asked me to continue DMC SSA Borpeta till my transfer from the district, only due to his confidence upon my working. That's why I had been working as an SCS officer since 1911-86, and during 2 years or 6 months of my service, neither any allegation was brought against me nor I did face any charge. That's why my date of superannuation falls on 31/5/2016, and I used to serve the remaining 1 year of service with utmost sincerity and dedication. That's why it was not my intention to commit any act of indiscipline and mislead my higher authority. It had happened inadvertently because of my high confidence level on the subordinate officer of staff of Borpeta. Therefore, I request you to kindly consider my above submission favorably, and charge which I hereby admit humbly may kindly drop in view of my superannuation in the month of May next, and allow me to discharge duty for the remaining days. Now, Your Lordship, here he has an admission, Your Lordship, and based on that,
This is in response to the show cause.
so forth.
So why do you say no opportunity was granted?
Lordship, I will come to that, Your Lordship. Before that, Your Lordship will kindly come to page 47.
Yes,
This is the order.
yes.
Whereas on the above findings, it has been, fourth paragraph, whereas on the above findings, it has been decided to award the penalty of stoppage of one increment upon so and so. Whereas the Assam Public Service Commission, who was consulted in the matter, has vied their order issued number so and so dated 27/10/2015 agreed to the Gov proposal to award penalty of stoppage of one annual increment upon the alleged officer, and therefore the government of Assam is pleased to award the penalty of stoppage of one annual increment upon Sri Basudev Das ACS, Deed and ADC cum District Mission Coordinator of Barpeta, presently so and so, North Assam Division Tezpur, and as the departmental proceeding initiated by so-called notice so and so is disposed of. Now, Your Lordship, for a moment, Your Lordship, I accept that there is an admission, Your Lordship, and this has been passed. Now, Your Lordship, my first argument will be, Your Lordship, this is order is received on the ground that, Your Lordship, the authority Assam Public Service Commission's opinion has not been furnished to me. It is the duty on the part of the disciplinary authority to furnish copy on me and seek my, Your Lordship, views on that. That's the law settled by this honorable court. I'll say hand over a copy of that or judgment to order. It will be the same. আমার হিসেবে judgment. হয়, হয়।
Mr. Surya, where is your colleague, Mrs. U Sharma? He was helping with that. U Sharma.
Views from তেওঁ এইটো
Available
letter মানে হেৰি কৰে ট্ৰাই কৰি আছিলে পাৰ্টনাৰ
Matter actually Upasana, he was appearing in this case on the Patar matter. However, my lord, I have seen that it impose a minor penalty.
No, no, no. We'll come to you. We are just asking you because it is a partnered matter. If you are not familiar, then you can request her, call for her. She was arguing the matter on behalf of the respondent. That's not an issue. I'm just expressing the view. Yes.
So far, I have gone, whatever I have
So
allowed.
let us complete the
Yes,
hearing
sir.
of the.
Lords.
Yeah.
Your Lordship will kindly take up this judgment, Your Lord. It will be the this is Your Lordship first our High Court judgment, Your Lordship.
Yeah. Yes, please.
Lord. Your Lordship में para 20 onwards, Your Lord. দেখো একটু দেখো Here also you receive one annual increment you wrote after completion of the 15%.
Yes.
Lordship, that's the one judgment, and your Lordship, SP Nirula, your Lordship, that has been relied on, that is there, your Lordship. Para 6, your Lordship.
Yes.
Report of the, we heard the learned councils for the appellant and learned council for the respondent. It is submitted by the council, the appellant, that the report of the Union Public Service Commission was not communicated to the appellant before the final order was passed. Therefore, the appellant was unable to make an effective representative for the ceremony as regards the punishment imposed. And therefore, your Lordship, we find that the stand taken by the Central was correct and the High Court was not justified in interim order. Therefore, we set aside the judgment of the High Court and direct the disciplinary proceeding as finally disposed of in accordance with direction given by the tribunal in para 6 of the order. May submit the representation within 2 weeks to disciplinary and make it clear that the matter shall be finally disposed of by disciplinary in a period of 3 months thereafter. Now, for that reason, your Lordship, this order of punishment is bad and vitiated in my humble submission, your Lordship. And in fact, secondly, your Lordship, if your Lordship comes to page 50 of the my petition, your Lordship, your Lordship will find the order of punishment was passed by the Additional Chief Secretary Dr. Basam, your Lordship. I have filed an appeal against that, your Lordship. Now, appeal, your Lordship, I have filed, your Lordship. They have considered it as an appeal, although I have written it as a representation, your Lordship. They have filed, considered it as an, and the same authority has disposed of the appeal also, your Lordship, saying that no fresh ground has been provided.
Which authority?
The disciplinary authority himself, your Lordship, as an pass the order as an appellate authority also, your Lordship. Your Lordship will kindly come to page 50.
Which is the appellate authority?
Appellate authority under this discipline and appeal rules, your Lordship, is the governor, your Lordship. They should have, your Lordship,
I don't know. Yes.
that is one aspect, your Lordship. And thirdly, your Lordship, on the point of admission, your Lordship, my humble submission is this, your Lordship. Ultimately, your Lordship, for holding a person to be punishable under your Lordship discipline and appeal rules, your Lordship, certain kind of, your Lordship, mens rea will have to be there, your Lordship. Not as, your Lordship, what criminal statute says, your Lordship, but at the same time, your Lordship,
We are not going to look into these aspects of
Lordship.
Why should we?
Lordship. That's, your Lordship, my
Why should we look into it?
Lord. But your Lordship, even if
Your only ground is whether non-furnishing of the
that will vitiate it or not.
APSC will vitiate the.
Lord. And that point, your Lordship, your Lordship, submission is this, and the judgments I have relied on, your Lordship, very specifically says, your Lordship, that will have to be
Narula judgment.
Lordship, Nerula judgment.
Where is the appeal order of the appellate authority?
Your Lordship, we page 50, your Lordship.
50.
Yes. It will put the- it will put the-
Yes.
Yes. This is your Lord.
Yes, Mr. Suthi.
Yes, my lord. Apparently, this is a minor punishment. minor punishment, my lord, he has transferred so many teachers without the approval of the mission director. That was his allegation. So, as per allegation, they inquired the matter and he has admitted it, my lord. So, page 47, the impugned order, my lord, of 5th of November 2015. This order says, my lord, third paragraph, the disciplinary authority in exercise of powers conferred by the sub-rule 4 of Rule 9 of the Assam Disciplinary Ethics Rules 1964 has examined the written statement in defense submitted by Sri Basudev Das in conjunction with the materials on record and found that the SARS officer has admitted the charges framed against him. So he has already admitted. Whereas on the above findings, it has been decided to award a penalty of stoppage only one annual increment upon Sri Basudev Das. The Assam Public Service Commission, who was consulted the matter, has filed under order dated 27 October 2015, agreed to the government proposal to award penalty of stoppage of one annual increment upon the charge. Now, question is, he is alleging this approval of the Assam public submission is not communicated to him. It is not necessary, my lord. It is a minor punishment, and it is a Ramzan case also, my lord. Inquiry report is to be submitted to the delinquent officer. In the ECL case also say it is not necessary. If the, my lord, there is no any, my lord, prejudice to the him. If not punishing of the PSC report, but how he is prejudiced, it is not stated anywhere, my lord. So it is not necessary. It is a minor punishment where minor punishment is there, my lord. Even personal hearing is not necessary. I am reading the rule, my lord. 1964 rule, minor penalty. If the disciplinary authority, having regard to its findings on the charges, is of the opinion that any of the penalties specified in clause 1 to 3 of Rule 7 should be imposed, it shall pass appropriate orders in every case in which it is necessary to consult the commission. Shall do so after consulting the commission. So they have consulted it. So one penalty is, my lord, 1 to 3 is, lordship, I am reading it. Censurate. Number 2, withdrawal of increments or promotion. The 2, sub rule 2 of Rule 7. This has happened. So, notwithstanding anything containing the rule, it shall not be necessary to follow the procedure laid down in the preceding sub rules in cases where it appears to be authority competent to impose the penalty at the initial stage of the proceeding, and that the penalty of censure would be adequate. But if at any later stage it is proposed to impose any other penalty specified in Rule 7, the procedure laid down in the said rule shall be followed. The only one increment stopped, that is the only penalty, and no other further penalty. No order imposing penalty of censure shall, however, be passed except after the government servant is informed in writing of the proposal to take action against him and of allegation of which the proposal to be taken and given proposal. So, so-called notice was given to him. He replied it, my lord. Thereafter, he admitted it. The admitted practice need not be proved. Then accordingly, they have imposed penalty. There is no any illegality, any perversity in passing this impugned order. So far, his furnishing the report of the APSC is not necessary. He only confirmed from the APSC. It is not an inquiry report. They confirm from the, as per rules, confirm. The APSC confirm it. The government proposal is
Not
correct.
confirmation.
My lord?
They have given an opinion on the punishment you propose to impose.
No, my
It
lord.
is not confirmation.
That is proposal. Proposal is here. Lordship policy order page 47. But the Assam Public Service Commission, who was consulted in the matter, has filed under order issued 1314 dated 27 October 2015, agreed to the GOV proposal to award penalty of stoppage once annual increment upon the charge. Agreed. Only they have approved it. That means agreed. And therefore, the Governor of Assam is pleased to award the penalty of stoppage one annual increment upon series so-and-so, coordinator Borpeta, presently so-and-so, and thus departmental proceeding initiated by so-called dated 20th January 2015 is disposal. So departmental proceeding is closed, imposing a penalty. That is, there is no any procedural lapse. If there is any law violate anything, that lordship definitely will interpret it. There is no any violation of the procedural matter. It is a minor penalty. Minor penalty in case personal hearing is not necessary. The competent authority can initial stage can impose. And that has been over now. That he can be promoted now. Promotion is not barred because he is on 2015 matter. So one increment after 16 he is entitled for promotion. But during the period of during the course of the penalty he is not entitled for promotion. That is law. I have so many case law here, regarding this. There is no prejudice. I am telling what is the prejudice on punishing of the FPSC information? Nothing much. They rightly imposed the penalty, because he has done so many teachers, 200, more than 300 transfer without any permission from the competent authority. He is not authority. ADC is not authority to transfer this contractual employee. That is his allegation. So Supreme Court says so many cases are there. There is no any.
Show us. You rely on the case laws.
Yes, I am giving. As case, yes, as case, I am relying. 1995 TSCC, State of Tamil Nadu versus small matter. And paragraph 7. Paragraph 7.
So this way we already seen.
Oh, I don't know, I
This-
was not
this-
there. And another
No, Mr. Sutia,
my lord.
this is on a point which he has already conceded now. He doesn't want to press this in view of these judgments.
I
No.
was not there.
Beyond that, you have to now support your case with authorities.
So 2015 to 16, he is entitled for promotion, I am not objecting in this case, So far, so far illegality and perversity of the passing the abuse order, I am submitting, non-furnishing of the FPSC information. Nowhere prejudice the petition. Anywhere, So my humble submission before Lordship, when imposing minor penalties, even he is not required to be heard personally, and the competent authority can impose penalty. This is one given only, and no more further penalty. That's why, that there is no perversity and illegality in following this procedure. And they are passing this order following due procedures. Togo's notice was issued to him, allegation, all these things are submitted with him, So nothing is there, I think that penalty has been imposed and that has been over.
Lordship, just for a moment, your Lordship, if your Lordship can take up Rule 911, your Lordship.
We are not complete with him.
Minor penalty.
What
Yes,
do you
sir, I am
say to
ready.
the judgment placed by the petitioner
Yes.
in SN Narula?
Then now I have not gone through.
You have not gone. You have to go through and address on this.
SN Naular case, where the penalty is major or minor, I don't know.
Huh?
Amar to minor.
Minor.
Which rule are you referring to?
911, your Lordship.
911.
911. Just now, my
Minor
senior friend
penalty.
has your Lordship. Your Lordship will see, your Lordship. If the disciplinary authority having regard to the findings on the charges is of the opinion that any of the penalties specified in clause 1 to 3 of Rule 7 should be imposed, itself pass appropriate orders, and in every case in which it is necessary to consult the commission, shall do so after consulting the commission, your Lordship. Now, your Lordship, if we go through the order, your Lordship will find that way also it is in violation of this. There is no question of proposing the punishment, your Lordship, approving it.
Rule 911.
11, your Lordship. 11. Your Lordship will see, if the disciplinary authority having regard to its finding on the charges is of the opinion that any of the penalties specified in clause 1 to 3 of Rule 7 should be imposed, it shall pass appropriate orders, and in every case in which it is necessary to consult the commission, shall do so after consulting the commission. Now, your lordship, here they have done what has they have done, your lordship. Apparently, from the order, they have only taken approval, your lordship. They should have done, your lordship, send the matter, took their opinion, then furnish a copy to me, and on the basis of my representation, they should have passed the order. Your lordship.
What is that rule you referred to, Mr. Sutia?
My lord,
No
rules-
hearing necessary?
These rules, minor penalty, 11.
11. Where does it say?
Minor penalties, my lord, thus he have read it.
He has written 911 itself.
911,
He has
Which part?
part, my lord, lordship.
Please read it again.
Yes. Minor penalties, my lord, if disciplinary authority having regard to its findings on the charges is of the opinion that any of the penalties specified in clause 1 to 3, 1 to 3 of rule 7 means minor penalties censure and swear. As should be imposed, it shall pass appropriate orders in every case in which it is necessary to consult the commission, shall do so after consulting the commission. So in this case, commission commission consultation is necessary. That's what they have taken.
No, you submitted that for minor penalties, even hearing is not necessary under the rules. That
Hearing is not done. Necessary.
Under
How
which
it is
which
done?
rule? Which rule?
I think in another case law, but I ever about not personal hearing. Yes, no, yes, no, yes. So we have read it, my lord. For today's I have not. I will have to start it. My lord. I have gone to erase minor punishment. Personal hearing is not necessary. Let it be, my lord. Under that, my lord, I will. His judgment. In his judgment, there is a judgment.
There is a judgment of the Supreme Court.
Supreme Court. So when the minor penalty is imposed, my lord, even personal hearing is not necessary.
I'm not on personal hearing, your lordship. I'm only on your
Not
lordship.
giving you opportunity. Personal hearing,
Opportunity.
giving you opportunity. That is the
Personal hearing is something different.
Personal hearing, giving an opportunity to place his matter. my lord.
The rules don't prescribe that.
Most time after.
Insofar as Narula case is concerned, I don't think that is a minor punishment.
No, that is not fine. But other one, our High Court, your lordship, is a minor punishment.
There is a major punishment. So the major punishment and minor punishment is different. my lord. That's why my lord,
Ultimately, your
proceedings are
lordship, whatever punishment, your
No, I
lordship,
have-
it has adverse civil
there. I
consequences
came
for
across
me.
this judgment.
Your
my lord.
lordship, ultimately, I got deprived from promotion. I retired in the meanwhile. Now, your lordship, it is your lordship. There are your lordship censure and your lordship reduction in increment. Your lordship. Out of these,
Minor
had I got an opportunity to submit my representation, I could have changed that to censure also, your lordship. Censure is also a minor punishment, your lordship. So, your lordship, that way I am prejudiced. Not saying that I have not been prejudiced. And that's why, your lordship, it is developed by the honorable courts, your lordship, saying that this will have to be given to him. Delinquent officer, your lordship.
So let me keep it part my lord.
It has already been part.
I don't know. second part. Right. And
Citation to police in Nerula. Already 22 more for this. 4 and 3. Eight to eight. That's the name. That's the name.
Let us try to complete it on day after tomorrow.
My part is already over. Only.
13.
I will.
13.
For
I'll be
further
out
hearing,
of station.
day after tomorrow.
13th, I will be out of station. My part is already over.
Yeah.
You will come.
Let the counsel for the petitioner concluded his argument with the right uh, for a reply if required. Counsel for the respondent also have rendered his argument, but like to place certain authorities. Therefore, the matter stands deferred to be taken up again on 13th. Matter to be taken as part of.
Deeply obliged.
I'm for accountant 18.
Huh?
I'm for 18.
You are for
Easy, accountant.
accountant, Mr. S.K. Mehdi for accountant. You have anything to submit?
Well, I support the
You support the petitioner?
Government.
Please state for it.
Obliged.
Who's for the petitioner? Who's filed the review?
State file this. The review petition.
What is the stand in the?
Senior Mr. Naik, he's on like, that will be taken up after some time.
No, you argue in his place. We'll give you the second file. Argue. Go through it. We'll hear the respondent in the meantime. Yes, Mr. Borua, tell us.
They have filed this review petition and the ground which is taken. The ground which has been.
No. What is there in the writ petition?
Right.
It's 2 years ago, the regular.
They have, the judgment of the judge directed the respondent to regularize my service.
Mr. Nayak has come. Let us
Yes,
see.
Lord. Lordship, this is a petition, Lordship, while praying for review of the order dated 21/9/2015, passing WPC number 3894/2013. Lordship, may kindly see the order starts from page 155. Lordship, relevant portion I am at page 159. Page 159.
Yes, paragraph
It starts from paragraph 17.
70. Yes.
17. In the light of the aforesaid legal position, the case of the petitioners may now be examined. From the above, it is evident that to come within the ambit of the
No,
one
tell us in a nutshell who are the petitioners?
lots of petitioners are were works as employees under PWD in Tezpur division, Lord,
Their claim was for regularization.
for regularization of their service. Accordingly, the court considered the case of the petitioner. Court also considered the one-time notification that was issued pursuant to paragraph 53 of the Umadevi judgment, notification of 2013. Lordship will find that notification at page 103. 103. Lordship may kindly come to paragraph 2. The state government will now like to take the one-time measure for regularization of those workers as referred to in paragraph 53 of the order in Umadevi's case, read with ML Kesari's case, whereby exception was carved out to regularize all employees who fulfill the following three conditions. These are important, Lordship. One, who have been working continuously for 10 years or more as on 10/4/2006. That is the date of passing of the judgment in Umadevi case without the benefit of protection of the interim order of any court or tribunal. Two, who have been engaged against sanctioned vacant post. And three, who have requisite qualification to hold the post. Lordship, if Lordship comes to the, so far as the condition 1 is concerned, Lordship, it's clearly stated as on 10/4/2006, the persons have to complete more than 10 years of service. That is, their appointment has to be prior to 1996. That is Umadevi judgment, Lordship. Lordship, in the present case, Lordship, most of the petitioners, Lordship, they were appointed subsequent to 1996. That is my basic point, Lordship. That was the apparent error.
Sorry, come again.
Lordship, in condition 1, Lordship,
10 years.
10 years, as on 10/4/2006, has to complete 10 years as on 10/4/2006. That means, Lordship, their appointments has to be prior to 1996. Lordship, in case of the petitioners, Lordship, most of the petitioners were engaged subsequent to 1996. So far as this notification is concerned, Lordship, in terms of this notification, they were not supposed to be considered for regularization, and that order should not have come. That is my basic point, Lordship. To show that, Lordship, if Lordship comes to page 61. Page 61. Lordship, this is a notification. Lordship, may kindly see the date at the top, Lordship, 26/2/1997. And at the next page, Lordship, page 62.
These are all promotion orders.
No, Lordship. This is the post, Lordship, which has been held to be a substantive post, Lordship. Serial number 14, Lordship. Serial number 14, next page 62, down below, Lord. In the interest of public service, Sri Nilodhar Deka, he was the petitioner number 13. Master roll worker of PW RNB Mechanical Subdivision, North Lakhimpur, is hereby promoted to the post of Workers Jugali. According to the court, Lordship, this post of
These for them to be promoted, for these people to be promoted,
Yes.
they are deemed to be in service in at some level. How else will they be promoted?
no, that substantive post, Lordship. Court say the post of Workers Jugali, the person was holding at that point of time, is a substantive post. So what was taken account of is the post of Workers employee.
No,
Similarly,
no.
page
What were they working as?
Workers.
They were promoted, na?
The
Promoted
promotion
to-
is only a misnomer, Lordship. There is no such promotion, Lordship.
We don't know
Master
that.
roll or Workers,
Your
Lordship.
no, your
They are
order
all
says
casual employees, Lordship.
your order says they were promoted.
Yes.
Prior to promotion, what were they holding?
Master roll.
Master role.
Yeah. So no question of master roll being a master roll to be a substantive post, Lordship. So even the Workers post, so Lordship,
Now these promotional posts are the workers posts.
yes, Lordship, as has been clearly mentioned in this order.
And what has the coordinate bench held?
14, 15, 16, 17, all were subsequent to 1996. Lordship.
What was the finding of the single judge?
If Lordship comes to the order again, Lordship,
Right in.
Seventeen, it starts from para 17. Para 18, Lordship.
Yeah.
From the above, it is evident that to come within the ambit of the one-time measure as envisaged in Umadevi and explained in ML Kesari above, three conditions would have to be fulfilled. In so far, condition number 1, one is one are concerned, or 1 and 3 are concerned, there appears to be no dispute to the claim made by the petitioner. Contentions of the petitioners to have rendered continuous service of more than 10 years, as on 10/4/2006, and having the requisite qualification to hold the post of Jugali and assistant blacksmith. In the case of the petitioner number 11, not disputed. It is also not disputed that the petitioners have been working without the benefit of protection of any interim order of any court or tribunal. The only bone of contention is regarding engagement of the petitioners against sanctioned vacant post. While petitioners contend that they are working against sanctioned vacant post, respondent 4 would contain that they are not working against. In fact, there are only 3 sanctioned vacancies in grade 4 in the establishment as on date, as against 20.
There is some opinion on legible, so the decision is already reported. So may take it.
I've got a certified copy. Yeah?
Yeah, oh, that one. Given to us is it not?
No, you can offer it to him if you think it is more legible. It will be helping him to read it.
Some word are missing. That
18. From the above, it is evident that to come within the ambit of the one-time measure, as envisaged in 1B and explained in ML Kesari, the above 3 conditions would have to be fulfilled. Insofar as condition number 1 and 3 concerned, there appears to be no dispute to the claim made by the petitioner. contention of the respondent to have rendered, petitioner to have rendered continuous service of more than 10 years as on 10/4/2006 and having the requisite qualification to hold the post of Jugali and assistant blacksmith. In the case of the petitioner number 12, it's not disputed. It is also not disputed that petitioners have been so working without the benefit of protection of any interim order of any court or tribunal. The only bone of contention is regarding engagement of the petitioners against sanctioned vacant post. While petitioners contend that they are working against sanctioned vacant post, respondent number 4 would contend that they are not so working, and in fact, there are only 3 sanctioned vacancies in grade 4 in his establishment as on date, as against 23 petitioners. But it is an admitted position that petitioners are being paid monthly salary in the pay scale of Jogali, and in case of petitioner number 11, in the pay scale of assistant blacksmith with grade pay and annual increment. Question of consideration is whether payment of salary in the pay scale of Jugali and assistant blacksmith for years together would be possible in the absence of sanctioned vacancies. In the proposal submitted by the respondent number 4, as per back as on 4/11/2009, giving details of sanctioned posts in his establishment, number of posts sanctioned in the cadre of assistant blacksmith was shown as 1 and number of posts sanctioned in the cadre of mechanical helper Jogali was shown as 22, total 23, as shown as filled up. These posts are being held up by the petitioner, and accordingly those have been shown as filled up. In the remarks column, it was mentioned that these posts were created by number so and so dated 26/8/1980. As against the above 23 posts, 3 workers were shown engaged drawing fixed pay. As a matter of fact, a statement as was also annexed to the proposal showing the names of all the petitioners holding the said vacant sanction post with pay scale, annual increments, etc. Therefore, despite protestations by the respondent number 4 to the contrary, it is quite evident that petitioners are being paid in the pay scale of Jugali and assistant blacksmith, which is a clear indication of the fact that they were working against valid sanction post. In the course of hearing, learned counsel for the petitioners has also placed before the court details of the sanction post in the establishment of the respondent number 4 for the year 2013-14, prepared by the respondent number 4, which also discloses 22 posts of mechanical helper Jogali held by the petitioners and 1 post of assistant blacksmith held by the petitioner number 11. Respondent number 4 has also prepared a statement showing the particulars of the petitioner and the pay scale drawn by them as on March 2012, including grade pay. Therefore, the above is clear indication of the fact that petitioners are working against valid sanction posts, carrying a definite pay scale with grade pay and annual increment. Moreover, as in the case of Nihal Singh, regularization of service of the petitioners would not create any additional financial burden on the state. In the light of the above, and considering the materials on record, court is of the unhesitant view that the petitioners have made out a case for regularization of their services as part of the one-time measure as per decisions in para 53 of the Umadevi, and as explained in ML Kesari, the ratio of the decision in Nihal Singh would also be applicable in the case of the petitioner. Therefore, it would be the duty of the PWD to submit proposal before the Finance Department, Government of Assam, for its sanction in terms of OM dated 27/6/2013 for regularization of the service of the petitioner, ordered accordingly. This shall be done within a period of 4 months from the date of receipt of certified copy of this order. The writ petition is accordingly allowed, no cost. So this was the order passed by the learned single judge. Now, after reading this judgment, Lordship, a question will definitely arise whether it was a mandamus or it was a direction to the authority to consider the case of regularization of the petitioner or not. Department took it as a direction for consideration of the case of the petitioner for regularization of their service. Accordingly, at page 183, Lordship, page 183, Lordship. A speaking order was passed by the authority after consideration of the case of the petitioner. Lordship, may kindly see office order, read the also at serial number 6, the Honorable High Court judgment and order dated so and so, passed in WPC number, WA number 45 of 2014. So this order was first subsequent to passing of the order by the division bench in writ appeal number 45 of 2014. Finding. Sri Soilendra Kumar Bora and 22 other petitioners in WPC number so and so were engaged as MR labor under PWD RNB Mechanical Division Tezpur prior to 1/4/1993. However, they were promoted to the post of workshop Jugali by the concerned executive engineer by order number so and so dated 18/5/1994 and 5/3/1997. 97, both of the data post 1/4/1993. On the basis of the cabinet decision, Finance EC2 Department by letter number so and so dated 22/8/2005 approved the regularization of the service of workers and MR workers of different government departments, including Public Works Department, engaged prior to 1/4/1993 by creating ex-cadre post, which is personal to the incumbent holding the post and automatically abolished when the incumbent holding the post relinquished in any manner. The name of Sri Soilendra Kumar Bora and 22 others petitioners in the instant case were left out in the list submitted by the submitted for regularization of services in terms of the above Finance Department letter, since their date of initial engagement in the then post, that is Workers Jugali, were after 1/4/1993. Agree for non-regularization of the services, Sri Soilendra Kumar Bora and 22 others, moved the Honorable High Court, though WPC number so and so. In the meantime, Finance Department issued Office Memorandum number dated so and so, dated 27/6/2013, wherein all departments were directed to undertake one-time exercise for regularization of services of employees who fulfill the following conditions. One, who have been working continuously for more than 10 years or more as on 10/4/2006, who have been engaged against sanctioned vacant post, and 3, who have requisite qualification to hold the post. The Honorable High Court by the order dated 21/9/2015, passed in WPC number 3894/2013, directed the Public Works Department to submit proposal before the Finance Department for its sanction in terms of OM number so and so dated 27/6/2013 to regularize the services of the petitioner. Accordingly, Public Works Road Department by the endorsement dated 19/2/2016 in the file number so and so submitted the proposal to Finance Department. In response, Finance Department's endorsement dated 6/3/2018, WR Department submitted the WR Department submitted the proposal intimating PWR Department submitted the proposal.
How is this relevant now for the review matter?
Lordship, after Lordship, in the meantime, petitioner filed one contempt case, Lordship, and
Therefore, the review.
And during the pendency of the contempt case, Lordship, one order passed by learned single judge which Lordship may see at page Lordship, if Lordship comes to the additional affidavit filed by the review petitioner starts from page 185. Paragraph 2, Lordship. Page 186. That the instant additional affidavit has been filed by the deponent in compliance of the Honorable Court's order dated so and so first in the instant review petition to state the reason for delay in filing the instant review petition. It stated that the instant review petition has been filed praying for review, recall, modification of the order dated 21/9/2015, passed in WPC number so and so. It further stated that in compliance of the order dated 21/9/2015 in WPC number 3894/2013, the Commissioner and Secretary to the Government of Assam Public Works Road Department passed a speaking order dated 21/1/2019, rejecting the claim of the petitioners for regularization of their services for non-fulfillment of criteria number 2 of the notification number so and so dated 27/6/2013, and standing Honorable Guwahati High Court judgment and order dated 8/6/2018 passed in writ appeal being WA number 45 of 2014. Accordingly, the state respondents in the said writ petition were of the bona fide understanding that the order dated 21/9/2015 passed in WPC number 3894/2013 has been duly complied with. However, in the meantime, a contempt petition being contempt case number 589/2016 was initiated by the writ petitioners, and it is during the proceedings in the said contempt petition by the order dated 6/12/2021, the Honorable Court first interrelated the observation that if the petitioners are of the view that the said conclusion in WPC number 3894/2013 is incorrect in the fact and circumstances of the case, the remedy would lie elsewhere. Thereafter, upon re-examination, it was found that the authorities that the post against which petitioners were working are not sanctioned posts. On the other hand, even if it is assumed that, though not admitted, that they were working against sanctioned vacant posts, as most of them have been engaged against those so-called sanctioned vacant posts not prior to 10 years from the date of judgment passed by the Honorable Supreme Court in the case of Uma Devi, which is one of the requirements of the notification number so and so dated 27/6/2013 issued by the Finance Institute Department. Accordingly, instant review petition has been filed praying for review, recall, modification of the order dated 21/9/2015 passed in WPC number so and so, taking a clue from the observation made by the Honorable Court in order dated 6/12/2021 in contempt case number 589/2016. It is humbly submitted that delay occurred. So this is the result. This was the order, Lordship. Thereafter, this review petition must be brought. So till that day, Lordship, it was the understanding of the department that it was a direction for consideration. Accordingly, after passing of the speaking order by the department, we have whatever order was passed, we have complied that. But Honorable Court pointed out that the remedy lies somewhere else, indicating that you may file an appeal or a review. So thereafter, this review was filed.
So where is the error?
But my first error is, Lordship, even particular point of time, a mandamus for regularization of service of works or
Why
employees.
should we take it in anything more than what is dictated, what is specified in the order? If it is not necessary for this court at least,
Yeah.
or for courts at least, coordinate bench, to decide whether it is a mandamus to appoint or a mandamus
Yes, that
to
is
direct.
in this review petition. That is why the review petition has come, Lordship.
No, but so how is that an error?
Lordship,
It calls
My-
for at
my-
best,
my
it calls
submission
for
will be-
a- calls for a clarification.
Lordship, my submission will be, Lordship. If Lordship takes that route, Lordship, that will be easier for me. But if Lordship comes to this judgment, Lordship, my submission would be, Lordship, misconception of fact as well as misconception of law both by the advocate or by the court, Lordship, is an apparent error, Lordship. That is the law settled by the Honorable Supreme Court. So my first submission will be whether at that particular point of time, Lordship, it was permissible for an honorable court to pass an order or pass a mandamus directing the department to regularize the service of an workers and
The contempt is file alleging what?
non-compliance of the order passed by the same order, which is under review. Lordship, why I am saying that those posts were held by the petitioners were not sanctioned posts, Lordship. One example I am showing your Lordship at page 61.
It is not consideration. You are directed to regularize.
Yes.
You are directed to submit a pen proposal.
In that case, Lordship, I have to proceed with this review petition.
Proceed.
Page 61, Lordship.
Yes.
I am taking 26 to 1997, page 62.
Yes.
Serial number 14.
Yes.
In the interest of public service, Sri Nilodhar Tai, his petitioner number 13, masteral worker of PWD RNB Mechanical Service, Mechanical Subdivision, North Lakhimpur, is hereby promoted to the post of Works as Jugali, vice Sri Pramod Chandra Hazarika, Works as Jugali, brought to the regular establishment and posted at North Lakhimpur under PWD RNB Mechanical Subdivision, North Lakhimpur. So this Nilodhar Tai was given the post of Works as Jugali, which post was earlier held by one Pramod Chandra Hazarika, whose service has been regularized.
Yes.
Means Lordship, Nilodhar, the post to which Nilodhar Tai was given engagement was not a substantive regular post. Lordship, may kindly read again, Lordship. In the interest of public service, Sri Nilodhar Tai, his petitioner number 13, MR worker of PWD RNB Mechanical Subdivision, North Lakhimpur, is hereby promoted to the post of Works as Jugali, vice Sri Pramod Chandra Hazarika, he is another person, Pramod Chandra Hazarika, Works as Jugali, brought to the regular establishment and posted at North Lakhimpur under PWD RNB Mechanical Subdivision, North Lakhimpur.
This has been clarified by saying that they are given regular scale of pay.
all workers employees gets regular scale lot. This get pay scale. All regular employees lordship, even those who were parties in the WA 45 of 2014 and workers employer lordship, they are also getting regular pay scale. They get regular increment lordship. They get everything except pension. Everything is same.
What happens if it is a personal post?
Personal post lordship, the post will get abolished once he is relinquished.
About pension?
As a temporary employer, 20 years qualifying period. The only difference these petitioners will have lordship, as their services were not regularized, they will not get pension. Otherwise, pay scale and everything, increment, allowances, everything is safe.
So the direction of the court is to send a proposal for regularization in the sanction post. Regularization.
Lord.
So according to you, regularization will require first creation of the post. If there are no posts.
No, in 2005 lordship, one batch has already been regularized around 30,000. Thereafter, these petitioners were left out lordship. Lordship, after coming into Umadevi judgment lordship, thereafter also we are processing files for regularization of left out workers and master employees. But in the meantime, in 2010 lordship, Jitan Goilta judgment came, where it was held that the entire scheme for regularization is not a valid one. In 2012 lordship, in a pending case lordship, before the division bench, we filed one leave petition seeking permission to proceed with the scheme of regularization so far as this left out master and workers employees are concerned. But the honorable division bench rejected that prayer. Thereafter lordship, in terms of Umadevi judgment, paragraph 53, we issued the notification of 2013. So as on date lordship, one person can be considered for regularization only going through the three conditions at paragraph 53 of the Umadevi judgment, which are the conditions in the 2013 notification of the finance department. No other option. Lordship, one judgment lordship I am referring to.
No. We are trying to understand the directions of the court.
Here.
What was the final direction of the
court? Said lordship, as the petitioners were receiving scale pay, so it established that they are holding substantive post. So that is what I am trying to show lordship. This paragraph 14, serial number 14. This is one only example. Lordship comes to pay serial number 15. Another petitioner lordship. Page 62. Page 62, serial number 15. In the interest of public service, Sri Trinoyan Hazarika, his petitioner
you are referring to?
Page 62, serial number 15, down below.
Yes.
Serial number 14, your lordship has already seen. He was given a post of workers in place of somebody whose services has been regular. Similarly, lordship, serial number 15, in the interest of public service, Sri Trinoyan Hazarika, master worker of PWD RNB Mechanical Subdivision Testpur, is hereby promoted to the post of Worksa Jugali. Bhai Sri Biren Kakoti, Worksa Jugali, brought to regular establishment and posted at Testpur under PWD Mechanical Subdivision Testpur. So the post given to him, in that post lordship, earlier this Biren Kakoti was working. And once Biren Kakoti's service was regularized, this post was given to Trinayan Hazarika. So definitely the post presently held by Trinayan Kakoti is not a substantive post, not a regular post. From order itself, it's clear, Lordship. Lordship may come to serial number 16. Same in case of everybody, Lordship. Somebody has been regularized, and his place, this particular petitioners were given engagement as workers employee. Serial number 16, page 63. In the interest of public service, Sri Dibyojit Dahal, masteral worker of PWD Road Division Mechanical Subdivision North Lakhimpur, is hereby promoted to the post of Worksa Jugali. Bhai Sri Rajendra Das Worksa Jugali brought to regular establishment. So Rajendra Das vacated the workers engagement as his service has been regularized. So in his place, Lordship, this petitioner, Dibajit Laha, was given the workers engagement. Same is serial number 17, Lordship. Same case in case of every petitioner. Somebody who was holding the workers post regularized. That is why this vacant post was given to the petitioner. 17. In the interest of public service, Sri Binod Chandra Gogoi, he is petitioner number 14, master worker of PWD RNB Mechanical Subdivision North Lakhimpur is hereby promoted to the post of works as Jugali. Vice Sri Purna Chandra Soikia works as Jugali, brought to regular establishment. Lordship, if this works as post, Lordship, to which the present petitioners were engaged, if that post is a substantive post, there would have been no requirement of regularizing the service of the person, Lord. I mean, the person who was earlier holding that post, his service has been regularized in some other post. This post fall vacant. And in this post, Lordship, post means works as engagement, the petitioner was given appointment.
So you're saying the single judge had allowed the writ petition?
Wrongly appreciating the fact that the
basing
petitioners
the
were holding.
conclusion that they were getting regular scale of pay.
The conclusion of the learned single judge was that as he was getting regular scale pay, that is why it has to be taken that the petitioners are working against sanctioned vacant post. That is why he is getting pay scale. That was the view taken by the learned single judge. But in fact, Lordship, this is not the fact. If Lordship comes to the paragraph 54, this is a notification of 1994. Same order, Lordship, just your Lordship has seen, Lord. All the petitioners were given engagement as workers in place of somebody whose service has been regularized. Lordship, it comes to page 58. This is another notification of 1997. Same promotion, Lordship. It starts from serial number 8 to 12. If Lordship comes to page 59. Page 59, serial number 8 is petitioner number 12.
'59.
59, serial number 8. In the interest of public service, Sri Trilushan Saikia, petitioner number 12, MR worker of PWD Mechanical Subdivision, Tezpur, is hereby promoted to the post of works as Jugali, Vice Sri Biren Kakoti Jugali, promoted to the post of in the same place. So he has been given promotion in some other place, that is why his place was given. Serial number 9 is petitioner number 22. In the interest of public service, Sri Ratneshwar Bora ordered the PWD RNB Mechanical Division, Tezpur, is hereby posted at works as Jugali, Vice Sri Rajendra Das Jugali, promoted and posted at Tezpur River. Same Lordship. So that is my basic submission, Lordship. These petitioners, the works as post they were holding, Lordship, were never substantive post, Lordship. In fact, they were given engagement to those works as post vacated by somebody else whose services in the meantime regularized. So these works as post fall vacant, and those places, positions, the petitioners were given engagement. In fact, that in the entire
There was
division,
no appeal filed. No appeal filed against the judge.
appeal has not been. So as these are apparent error to in my humble understanding, Lord, I am praying for review of this order, Lord. Lord, may kindly remand this matter back to Learned Single Judge again, Lord. The court will take this matter. Lordship, say one judge, 2-3 judgment, Lordship, I would like to place. Notice to the answer. First, Lordship, I'm taking 2006-4 SCC 1.
Okay. Madhav.
Yes.
Paragraph 53, Lordship, page 42.
Yes.
Paragraph 53. One aspect needs to be clarified. There may be cases where irregular appointments, not illegal appointments, as explained in S.B. Narayanappa, R.N. Narayanappa, and B.N. Nagarajan, and referred to in paragraph 15 above, of duly qualified person in duly sanctioned vacant post might have been made, and the employees have continued to work for 10 years or more, but without the intervention of orders of the court or tribunal. The question of regularization of the services of such employees may have to be considered on merits in the light of the principles settled by this court in the cases of above referred to, and in the light of this judgment. In that context, the Union of India, the state governments, and their instrumentalities should take steps to regularize as a one-time measure the services of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts, but not under cover of orders of the court or of tribunal, and should further ensure that regular recruitment are undertaken to fill those vacant sanctioned posts that require to be filled up in cases where temporary employees or daily wagers are being now employed. The process must be set in motion within 6 months from this date. We are also clarify, that is, this is very important, Lord. We also clarify that regularization, if any, already made but not sub judice, need not be reopened based on this judgment, but there should be no further bypassing of the constitutional requirement and regularizing or making permanent those not duly appointed as per constitutional scheme. So this is the hurdle before us, Lordship. Subsequent to this judgment, those who have been already regularized, their services were regularized. But in any future regularization has to be done by only by fulfilling this condition. Next one judgment, Lordship, I am placing. Manipur. 2007 10 SCC 544. Two 10 SCC 544.
Yes.
The state of Manipur and others versus Moirang Tongpur. Paragraph 7, Lord. Paragraph 7.
Yes.
We are of the opinion that in view of the Constitutional Bench judgment of this court in Secretary State of Karnataka versus Umadevi, this court cannot direct regularization in service. Since the court has no power to direct regularization, it is also follows that it has no power to direct grant of benefits payable to the regular employee. So this is my case basically, Lordship. If this is a judgment, Lordship, if the Supreme Court even cannot pass a direction for regularization, it would have not have been possible for our High Court, Lordship, or a High Court, Lordship, to pass a mandamus. And that is why I am saying, Lordship, it is our bona fide understanding that it was a direction for consideration of regularization, and in fact, it was not a mandamus. So this is the second judgment, Lordship. Then Lordship 2008 10 SCC 1.
Yes. The review is error apparent.
Yes, sir. That is what I am saying, Lordship. That is
Error apparent, does it include further interpretation of the error apparent means see your document says something else, conclusion is something else.
then I
wrong
should
application of law.
in if that is so, Lordship, then I have to.
So this is just
I'm not
just
required to
a
go.
passing thought.
Yes,
It is possible that in a particular case,
Lordship.
review, one can go into the interpretation of how conclusions were arrived at.
Lordship, in that situation, I am not even required to go beyond page 58 to page 63 of this petition, Lord. Your Lordship has seen the orders by which they were appointed.
What is this judgment? Ilmo Devi.
Ilmo Devi is a judgment, Lordship. There the Supreme Court held that court cannot even direct the authority to initiate a scheme for regularization.
Paragraph?
Another judgment I am taking, Lordship, on the same line, Lordship.
No, this Ilmo Devi paragraph?
Ilmo Devi paragraph. But another judgment I am citing, Lordship. 2011 2 SCC 429.
Yeah, 2000?
2011 2 SCC 429.
Ilmo Devi, I think it is
Same.
8.4, 8.5. Especially the last line of para 8.4. Perhaps this is what you want to rely on. Yes, 2011 2
Yes.
SCC.
The High Court, in exercise of powers under Article 226 of the Constitution, also cannot direct the government and or the department to formulate a particular regularization policy. So why I am repeatedly submitting these judgments, Lordship? Only because of the fact that this is not a mandamus, Lord. If it is a mandamus, Lordship, then at that point of time, these judgments were not placed, Lord. If it has to be taken as a mandamus, Lordship, it would not have come if those judgments would have placed at that point of time.
These are later judgments, I think. No.
Prior judgment, Lord. 2011, 2007, 2008, 2006. Lordship,
Yes.
next judgment, Lordship, 2011, 2 SCC 429. .435 page, Lordship, paragraph 12. .12.1, Lordship, and 12.5, 12.4. 12.1 states, Lordship, the High Court, in exercising power under Article 226 of the Constitution, will not issue directions for regularization, absorption, or permanent continuance unless the employee claiming regularization had been appointed in pursuance of a regular recruitment in accordance with relevant rule in an open competitive process against sanctioned vacant posts. And if Lordship comes to serial number 4, Roman 4, 12.4, part-time employees are not entitled to seek regularization as they are not working against sanctioned posts. There cannot be a direction for absorption, regularization, or permanent continuance of part-time. So 1 and 4, it also covers my case now.
Yes.
One judgment, last judgment, Lordship, I would like to place Lordship. This is 2008 10 SCC 1. Official lecture. Paragraph 75, Lord.
Yes.
Paragraph 75.
Yes.
By virtue of Article 141 of the Constitution, the judgment of the Constitution Bench in State of Karnataka versus Umadevi is binding on all the court, including the court, till the same is overruled by a larger bench. The ratio of the Constitution Bench judgment has been followed by different two-judge benches for declining to entertain the claim of regularization of service made by ad hoc temporary daily wage casual employees or for reversing the orders of the High Court granting relief to such employees. Some judgments has been made. However, in UPSCB versus Puran Chandra Pandey, on which reliance has been placed by Sri Gupta, a two-judge bench has attempted to dilute the Constitution Bench judgment by suggesting that the said decision cannot be adopted to a case where regularization has been sought for in pursuance of Article 14 of the Constitution and that the same is in conflict with the judgment of the 7 judges bench in Maneka Gandhi and Union of India. The fact of UPSCB versus Puran Chandra Pandey, where that the respondents, 34 in number, were employed as daily wage employees by the Cooperative Electricity Supply Society in 1985. The society was taken over by Uttar Pradesh Electricity Board in 1997. Along with daily wage employees, Earlier to this, the Electricity Board had taken a policy decision on 1996 to regularize the service of the employees working on daily wages from before 4/5/1990. Subject to that, they are passing the examination. The respondents moved the High Court claiming benefit of the policy decision dated 28/11/1996. The learned single judge of the High Court held that once the employees of the society became employees of the Electricity Board, there was no valid ground to discriminate them in the manner of regularization of service. In the matter of regularization of service, the division bench approved the order of the single bench. A two-judges bench of this court dismissed the appeal of the Electricity Board. In paragraph 11 of judgment, the two-judge bench distinguished State of Karnataka versus Umadevi by observing that the ratio of that judgment cannot be applied to a case where regularization has been sought for in pursuance of Article 14 of the Constitution. The two-judge bench then referred to the State of Odisha, Sudhanshu Sekhar Mishra, Ambika Query, and so. 16. We are constrained. Dr. I am skipping this portion. I am coming to paragraph 77. We have carefully analyzed the judgment of the two-judge bench in Puran Chandra Pandey case and are of the considered view that the above reproduced observations were not called for. The only issue which failed for consideration by the two-judge bench was whether the daily wage employees of the society, the establishment of which was taken over by the Electricity Board, along with the employees, were entitled to be regularized in terms of the policy decision taken by the board, and whether the High Court committed an error by invoking Article 14 of the Constitution was relieved to be writ petition. The question whether the Electricity Board could frame such a policy was neither raised nor considered by the High Court and this court. The High Court simply adverted to the fact of the case and held that once the daily wage employees of the society became employees of the Electricity Board, they could not be discriminated in the matter of implementation of the policy of regularization. Therefore, the two judges bench had no occasion to make any adverse comment on the binding character of the Constitution bench judgment of the State of Karnataka. But ultimately, the judgment was declared obiter dicta by this bench of the Supreme Court.
Which judgment?
That Puran Chandra Pandey law.
Yes.
My basic submission will be, Lord, if one goes to the order by which these petitioners were engaged as workers employees, it is quite clear that they were only engaged as workers and their posts were never substantive posts. That is one. And secondly, Lordship, even if it is held to be a mandamus, Lordship, these judgments, Lordship, these relevant judgments were not placed at that point of time, Lordship.
Yes.
So these are the apparent error, Lordship. Accordingly, I
find it. You had placed two other judgments. One is Kesari
ML Kesari, Lordship.
and one single bench judgment.
ML Kesari is regarding that 10 from which date the date is to be 10 years is to be counted, Lord. 10 years from the date of Umadevi judgment, Lord.
Yes.
Lordship.
Yes.
Lordship, one judgment, Lordship, I would also like to place AIR 2005 SCC 592. So, Lordship, right now that judgment is not with me, Lordship. It is BCCI versus Netaji Cricket Club.
What is it?
AIR 2005 SCC 595.
AIR 2005 SC.
SC, yes, 592. That BCCI versus Netaji Cricket Club judgment noted. There it was held that even misconception of facts or misconception of law, both on the part of the court or on the part of the advocate, are also apparent error law.
Yes.
May I- First one submission is this, that it is a review application. I cannot go in review, because I cannot go to the merit of the case. They cannot get to the merit of the case. And they cannot go to the merit of the case and the observation of the court. They must have to show that the error appeared on the face of the record. Their whole submission, which I have gathered from his argument, that they said the judgment is wrong. Judgment is wrong. But they have not shown anything which shows is error apparent on the face of the record. And subsequently, he also said that there is a decision of the larger bench, and on basis of which the order should be reviewed. This subsequently of this judgment. As they have said,
When is that larger bench judgment?
read appeal.
Which larger bench judgment?
Read appeal, division bench. The one division bench
In the
judgment, is they said,
speaking-
one
in the-
division bench done the read appeal is
In the speaking order, Lordship, that division bench judgment
judgment was given. They relying on that.
W
They said that therefore the situation is changed.
Upendas.
Open does, and therefore this one should be reviewed. As they have showing that many things, Lordship, before Lordship, I only place 2 pages because I cannot go to the merit. Lordship kindly pointed to 154 and 56. Lordship, 148. Lordship, which is at the time of before this learned at the time of hearing. That is their document. It is not my document. 148. Page 148.
Yes.
Here also you will find the works of establishment. You will find that they are giving a chart. They are giving the post indicated there.
Serial number 2 and
Serial number 3,
2 and
2 and 3, and the creation of post and scale of post and number of post sanction. That's it, fine. That is their document. At the time of hearing, that is also indicated in the judgment also. And the creation of the post also given in the remark column. That is therefore the honorable court also indicated that. And then also will find 156 and there are 154 and 56. 154 and 56. 154, page 154. It is their document. That the employee who filed the case and the working present. Annual, you will find the pay scale is giving sanction for the budgetary provision allocation budget for the workers, and the last annual retention is also given there. And that these documents are considered by the court and passed the reason order. Every day sanction, what a proposed sanction, where the regular, all are specifically deal with by the court. And therefore, once they deal, there may be, they say they're not satisfied on that, they may be, there is, on that part, the review cannot be maintainable. For the review, it is not a appeal in disguise. It is a review. You have to there apparent in case of the record. After our submission, I will giving the judgment of one constitutional judgment, and regarding particularly on the case of the error upon what to be recorded and the what would be ratio, and therefore I do not want to go to the merit of the case because Lordship may not go to the merit of the case. And Lordship rightly said in that they must show the error apparent in the place of the record. And well-reasoned judgment normally should not be may not be interfered in reviewed petition. I am starting my want to start my argument by a quotation of Justice Krishna Iyer, which is given in the 1982 SCC 167. I'll place all this that what the Justice Iyer says, a plea of review, unless the first judicial review is manifest distorted, manifestly distorted, is like asking for the moon. A forensic defeat cannot be avenged by an invitation to have a second look. Hopeful of discovery, close and reversal of result, a review in counsel, mandation cannot be repaired the fabric once again. So law down must rest in peace. Therefore, my answer, if they fail, they are ground. I will take the one by one. They are ground. To satisfy Lordship, I have to go to judgment letter. What they taken in ground, Lordship will find their petition. What they ground they have taken. Ground, page 27.
Yes.
Let me find grounds. I am not saying that there is nothing to say. B. For this honorable Udart concerning material fact in case well relevant office record has passed in data date of petitioner according liability with. My submission is the judgment itself says there is 2 affidavit filed by the department, 2 responses given by the petitioner, and placing the record, and after considering the all relevant records placed by the department, which they admitted that they are working, they are getting the regular scale. They only once said that for budgetary provision we have sometimes giving in then as working at regular sector because so that the budget can be passed and they will get the pay. That is not considered by the court with the order. Speaking is everything is discussed at the end. Therefore, the all thing is considered. There is no and that is also there is no question of apparent in record. If the material is such a thing, what is apparent record? I will by judgment I will place it before your Lordship. And C Lordship find while back to state the WBC, there is very serious thing. The court was an erroneous assumption. If they say it is an erroneous assumption, Lordship kindly page 51. Page 51. He shows Lordship is different appointment, appointment letter, but intended skip in page 51. Page 51, Lordship will clearly say page 51. In accordance to the recommendation of selection of the communicated member of secretary, Megan results over. It Lordship will find in 5 paragraphs that there itself says that selection and the promotion and this document itself shows the regular due to date of this also. And my petition number 16 and 2 is there, CL number 14 and 15. And this document also say, consider that the court presumed that they are working a longer period of the regular pay of scale, and their document says they are against sanction, and the court put in question when a person given an irregular grade paying and regular scale in the judgment says, how a longer period of time they can say without having sanction for? How can a budget can pass without that quoted question that in the judgment? And answering that, the court said that it cannot be a judgment. That was well-reasoned judgment, and therefore that this ground is cannot be sustainable. And the review petitioner begged to state that during the execution proceeding, the public law department could not produce some vital document. If they could not produce vital document, two affidavits is filed, document given. Now said that some document is not given. That cannot be a ground for the reviewing a reasoned judgment. That cannot be a ground for a reviewing judgment. There cannot be a ground for the review a well-reasoned judgment. And the documents supporting the factual errors are enacted. What are documents they said? That is the engagement of the petitioner were not properly placed. Page 51, Lordship, I have shown you, Lordship, that all appointment letter is annexed with the read petition. Therefore, this cannot be say that now say the document is not before the court. Document was before the court and considered that those documents. And second, the fact of getting space scale is not indication. The fact that they are working against it and so on. That is what this is. This is clearly discussed in the judgment. Once it discussed in judgment, we cannot go to the merit of the in review petition.
Yes.
And document there's a 3. That is page 51, whatever appointment are already given. And a letter dated 2011 level which will never place before the court. Placed before the court honorable which claim file is 261 posts. Page 148, Lordship, kindly have a look. No? 148 and 149. They have placed all this document. Now said this document which they annex in the affidavit is not placed. It is very ridiculous. It cannot be said. Therefore, they are the ground. They have failed to show the ground. There is a error apparent on the part of the court. Therefore, my submission, there cannot be this is down for a review petition. First, Lordship, I will rely on
What
judgment.
do you say with regard to this Annexure 6?
Is
Which
148,
finds
Lordship,
reference
fine.
at page 29.
149.
is Lordship.
For all document they now say about this, all document before the court and the court considered. And after considering the reason, giving a reason under, they cannot go to the merit of it. It is not an appeal. They cannot go to that extent. Now I say, therefore, it is not me to proper to re-appreciate the judgment again. And my only I have to show that there is no error apparent of the page that I failed to show. And the subsequent judgment cannot be ground for review. I will place the pronouncement of this constitution order that is the Aadhaar card case, Lordship, what is it? I will place before you first. Lordship, kindly take my first order I give it to Lordship. That is 24 to SA 362. So I have a copy. I have given you a copy. And Lordship, I directly Lordship to lead to the para 7 of the judgment. That is scope of review. Para 7 of the judgment. The scope of review. At the outset, Lordship got it?
Yes.
At the outset, it may be stated that power to review its judgment has been conferred on the Supreme Court by the Article 137 of the Constitution of India. Of course, that power is subject to the provision of any law made by the Parliament or rules made under Article 145. Supreme Court exercise the powers conferred under Article 145 of the Constitution of India has framed the Supreme Court rule. The order for therefore, the deals with the provision of review. According to civil proceeding, in a civil proceeding, an application of review entered only on the ground mentioned under Order 7, Rule 1 of the Code of Civil Procedure and criminal proceeding on the ground of the error apparent on the face of the record. However, it may be noted that neither Order or Order 7 Supreme Court rule limit to remedy of review only to parties to the judgment under review. Even third party to the proceeding, if he considers himself an aggrieved person, may take recourse to remedy of review petition. The condition is that the person to aggrieve is judgment or order passed by the court in some respect. In view of the said legal course of review petition who claim to be an aggrieved person, but the imputed judge were permitted to review and were heard by the court. Before avoiding the contention raised by the learned counsel for parties, let us these well settled law on the scope of review and contemplate under body and for the Supreme Court rule and read under body on GPC. And next para 9. The word of Krishna, what I am arguing my case, starting my day. The word of Krishna, in his lordship, the plea of review, unless the first judicial review is manifestly distorted, is like asking for the moon. A forensic repeat cannot be avenged by the invitation and to have a second look, hopefully to discover a flaw and reversal of result. A review cannot be body getting under. It is well settled. It is well settled that parties are entitled to seek review of a judgment delivered by the court merely for the purpose for a rehearing and a fresh decision of the case. Normal principle is that the judgment pronounced by the court is final, and departure from the principle that which is justified only when circumstances substantial and compelling character make it necessary to do so. In present day, when the court made this very pivotal observation. Order 47 Rule 1. A judgment may be open a review entirely. There is a mistake on apparent in the face of the record. An apparent which is not self-evident has to be detected by a process of reasoning. Can hardly be said to be error apparent of the face of the record. Lordship kindly. Okay. The apparent, Lordship, for a moment, earlier Lordship said, the apparent, Lordship said, the apparent you have to say that is wrong. Lordship correctly said. By justification, by evaluating a document, you cannot say that this is an error apparent in the page of the record. Justifying the court to exercise the power of review under 47 in exercise of the jurisdiction 47. The permissible for an erroneous decision and reheard and corrected. They want to, every time they want to check the Uma Devi and the judgment they have, showing your lordship, that the binding of a case, you cannot give a direction of a regulation. That cannot be. That cannot be done for review. That cannot be raised in a review petition. And even they cannot be raised because even the court is justified. Court, lordship will find it that order, judgment, discuss the Uma Devi, the exception of Uma Devi also dictionary in the Kesari case, and also thereafter there's another case came at the time, the Nihal Singh, and it dealt that at time of arguing the case, that case that they done what they have giving the lordship giving the that decision of that decision, the considering all aspects they said that what they memorandum to they justified our case, that it is include satisfied that point, and they cannot say in review petition evaluated that it is not an appeal in disguise. They cannot say there is no apparent. In fact, they can show that apparent in face of the record. Now, paragraph 12. Again, in Shanti Conductor Private Limited, Assam State Exam others, the three branch of the court following the person dismissed the review petition, holding that course of a review under the guise of review, the petitioner cannot permit it to re-agitate a new agreed question we have already argued and decided. The question raised was already been decided by the court, and that argued by them. That it cannot be again decided in the review petition. Paragraph 13. Recently, in Sri Ram Sahu reported dated 2021, 13 the court debated law with regard to scope of review under section 114 and 849 of CBC. Now,
Yes.
Paragraph 15. From the above, it is evident that a power to review cannot be exercised as an appellate power and has to be strictly confined to the scope and ambit of the Rule 1 CPC. A error on the face of record must be such an error which mere looking at this record to strike and it should not require any long drawn process of reasoning on a point where there were conceivable and two opinions. Therefore,
We'll come back.
Yeah.
We'll come back. Yes. So, only error apparent,
yes,
no hearing in disguise.
so far my argument was giving regarding the scope of review and the judgment paragraph 15. Basically, from the above, it is evident a part of review cannot be exercised as an appellate power and has to strictly confine to the scope and ambit of the body rule 1. An error on the face of record must be of such error which mere looking at the record to strike it should not require long drawn process of reasoning on the point where they conceivably. That is my submission or counter to that what they are going to project to evaluating in some document which already been considered by the court. But in a review petition, they cannot do this. And court may not go to such extent. It become if we go to that sense, it becoming an appeal of the order. Paragraph 16. The gist of the aforesaid decision is that in that conclusion, a judgment is open to review entirely if there is a mistake, an error apparent on the face of the record. A judgment pronounced by the court is final and departure from the principle is justified only when circumstances substantial and compelling character make it necessary to do so. An error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record and justifying the court exercise power of review. They, on giving the BCI case, they want to say the misconception of the document, but there is no misconception of the law, or neither there is misconception of the document. The law, there is the court, uneasily the analysis the decision of the apex court, and therefore that part they cannot do in the case of the review. And in exercise under jurisdiction of 47 Rule 1 is not permissible for a erroneous decision and reheard and corrected. They constantly said that this should be, the court cannot do this, giving the right from the Umar Devi. In review petition, cannot be read and corrected. If they show they agree, they have to, there is another forum to do. A review petition has a limited purpose and cannot be allowed an appeal in disguise. Under guise of a review, petitioner cannot permitted to re-agitate the re-argued question which have already been addressed and decided. And only this judgment, this gist of the judgment is given there. An error on the face of the record must be such an error which is looking at a record to strike to the required. That is already been indicated in very parts of the case when he is arguing. The apparent should be apparent. The document you cannot re-evaluate. Evaluation is not a error face of the record. Even the change of law is subsequent decision. Judgment of a coordinate or larger bench cannot be said regarding grant of review. So they're showing the additional affidavit to the, they said that Upendra's cases was subsequently the Upendra's cases were. The law is very clear. And that grounded that they cannot be gone for review. At the time of the passing the judgment, what are in that time is irrelevant. The coordinate and larger events cannot be itself. And this decision, Lordship place it, this point is already been decided also by recently in constitution bench. I will place after this point, on this point.
Which point?
They say that Upendra's case, read appeal, all this thing, that larger bench, that now we cannot regularize. That is cannot be a question of review. Analysis, then national analysis. The effort, keeping the aforesaid legal stated legal position, let us examine the whether review petitioner have been able to make a. After the lordship will find there ground. I have specifically in every ground I say lordship placed before your lordship that there is no ground at all which is error apparent or fulfilling any condition of the review, and the court can only go on that part of the error apparent. They cannot go beyond that. And lordship after in this case also, coordinate bench giving some judgment, defiant judgment on basis of that the review is sought. Paragraph 27. Taking account of the state observation made by the coordinate bench, the learned council review petitioner have argued that review the state submission of learned council for review deserve to be outrightly rejected. For the simple reason that passing the reference to the improved judgment made by the equal to the requirement. And finally, the court observation is that paragraph 27. In the final observation of the case, in view of the above, we are opinion that paragraph that the well-reasoned judgment, well-considered judgment, so the review does not fall into the scope of the ambit of review. The learned counsel for review have to fail to make out any mistake or apparent on the face of the record in the improved judgment and have failed to bring the case within parameter of laid down by various decisions of the reviewing judge. So we are not inclined to enter into this review. And the was discussed. Thereafter, lordship, I will place. Another judgment. It is 2024 6 SSC 461. Here also, analysis the scope of review. Here also, They take it from the earlier judgment, and that part I will not take time to stipulate another. The scope of review, paragraph 22. Here also, the Krishna judgment is given. Therefore, Lordship will find it
22.
22. At 23.4 and 23.5 as giving the law related to the review. And in para 24, he relates that what is the similar to the other law of the review regarding review 114 and 147, how it is came. 26, what you will find, paragraph 26 is end of the mistake error apparent on the facial record would be divided court from acting the appellate court in disguise by indulging the rehearing. A decision, however erroneous, paragraph 26, can never be a factor for review, but can only be corrected in appeal. Such a mistake or error would be self-evident on the face of the record, and the error should be grave enough to be identified, and a mere cursory look and omission so glaring that it required the intervention in the form of a review. Being the KSR of a statute, there is absolutely no room for fresh hearing. The court has got the role of involved itself in the process of adjudication of a second time, instead of merely examining the apparent mistake apparent in law. Even when two views are possible, the court shall not indulge itself by going into the merit. And paragraph 27, the material produced at this stage should have, and the material, what material should be placed? Review is a very piston in quality, and then only taken into consideration. Paragraph 28, Lordship will find a subsequent event per se cannot form the basis of review. And precedent in also, Lordship will find that a very detailed judgment is paragraph 30, is not gone for. And paragraph 32, the court clearly discussed the various what is error apparent at the face of the record. Paragraph 32. And therefore, it is settled position regarding so far the review is application is concerned. There must be a, they have to show there is error apparent on the face of the record, which they could not establish. Their ground is only that this document is not clearly appreciated. That cannot be a ground, which court had taken into consideration and giving his observation, and they can substitute that in review. Even for the time that the evening judgment is wrong. Which is judgment not corrected. The review petition cannot correct that judgment. Review, that is, they cannot be a ground for review. Therefore, they could not able to substantiate the basic condition of the review in their petition. That the ground taken by them is not come under the purview of the review. All documents are considered the well-reasoned judgment, and the judgment they relying is amount to say that the correctness of this judgment. The merit of they cannot go to the merit of the judgment in the review petition. And there's subsequent event, Lordship, there is a constitution-based judgment I was just placing before Lordship. I'm not much time of that. The second was very judgment, it says that pair of the court was order permission to the review the college is that pair of the open court. The present review petition have been filed.
You are reading from
With page 2, let's say final page.
subsequent
Second
judgment.
editor.
Next
The pair to the present review. Present review have been filed. The final judgment order dated, and so we have priority review petition well grounded there. The method. We have said that a change in law in subsequent judgment of a coordinate or larger event, it cannot be the ground for review. Review petition accordingly dismissed.
Yeah.
That is the code, in judicial review code constantly you cannot file a review in a guise of the appeal. And this review petition has been filed after 7 years of this, after 7 years of the judgment. After 7 years of the judgment, though in review petition there is no limitation, but there is a concept that any court, therefore the court asks him to explanation why the delay has been in cost. They said when the contempt petition is filed for non-compliance, the court gave on 28/1/2020, the court say they place the order, one speaking order. The court say it itself is a contempt. Court observe, they said that we'll take a look on that. And thereafter, 6/12 the court examined when 6/12/21, when court examined the matter, they said that if you are passing that order, your remedy is not here. Your remedy is like court is very given the direction, your remedy is like elsewhere. Contempt petition, by filing this order, you cannot get a remedy. Then elsewhere means they have to go for the appeal, but they said already they have passed 7 years. After that order, they filed this review petition and taking those ground which is not at all tenable in the review petition. My humble submission before this court, the ground taken by the learned the petitioner of the review petitioner, which is stated in their petition. I have showing that one by all that is not at all the ground under order 47, and there is no any ground. Where page 28, Lordship will find 27. The ground is giving it page 27. There is no any ground whatsoever, and showed by the petitioner that these are his error apparent. Nothing in the that showed. They showed that documents that they want to say that they are the court has erroneous assumption. What is that you cannot say in review petition. In review petition, the court observation was that after giving court questioning that after giving the regular pay scale, giving a budgetary allocation for a longer years, more than 10 years you have given, and how you can say there is no sanction where your review, your budget allocation, when they are paid, shows they created a sanction for creation. And if they say now that are only for purpose of budget, then they cannot be tenable. And finally, the court said that if taking the consideration of the indicating the judgment of the appeals court after consideration what is passed after Umadevi and judgment in which the Umadevi is also considered, that clearly the court observed that after considering Umadevi, KL Kesi and Nihal Singh case, considering all three cases, it is came out found that the petitioner is entitled for the regulation and directed him to do to their fulfilling the condition of the OM and the director for regulation. That is the case. That is the case. There is no. They have not they have not. Their argument is based on only two. There is no argument in lead and placing before this court. There is this document is error apparent in the face of the record. They even could not show any justificable reason to even the court have not considered that they are document. Even that is not a ground for review. The submission there is that giving the judgment, what is judgment? Judgment said that the court cannot give in the direction for regulation. Court cannot give the Uma Devi. But what
do you say with regard to the judgment referred to by the
commissioner? Yes.
Regarding that Netaji Cricket Club, BCCI.
New document. That is the new document.
Yes,
BCCI versus Netaji.
BCCI case is new document. New document. Discover a new document. But that is not our case.
No. Not only new document.
And misconception on misconception of law. And misconception, what is misconception will come from the document. That this document is a misconception. But the court have a particular deal with the matter. There is no question of misconception. The court has specifically for a moment.
There are nine.
Court have particularly listing court had considered paragraph 13 Lordship will find paragraph 13 of the judgment. Paragraph 14 of the judgment.
Of which judgment?
Paragraph 14.
Judgment impugned.
Judgment of the impugned judgment. The judgment which sought to be reviewed.
Yes. Paragraph?
Paragraph, Lordship will find a paragraph 14, 15 and 16.
Yes.
17, 18, 19 and 20 Lordship will see all facts, what if they raise is 13 Lordship in case of Supreme Court that explained the exception carved out by Uma Devi is considered, Lordship fine. Uma Devi is considered. The government instrument are take regular, expend time of one-time measure. 14 Lordship will find the finance go OM. That one-time regulation. They have considered the OM also, the court considered. And from an opinion. And 16. In the recent decision, Lordship will find very important, paragraph 16. In the recent decision, Amar Khan Rai versus Bihar, civil appeal, it is a new judgment. At that time, it was not reported at that time. In the recent judgment, in case Amar Khan Rai says of Bihar civil appeal, decided on March 23, the Honorable Supreme Court explained the rationale behind the exception carved out in Uma Devi. According to Appeals Court, the objective of permitting regulation of such appointment and which is irregular but not illegal, and the ensure the security of employment those whose person have served the state and the state for more than 10 years. In the state decision, reference has been made to Nihal Singh, 2013, 14, in that case, it was held that there is a clear existence of need of creation of a post of absorption, while acknowledging that creation of the post necessarily means additional financial burden on the scale. However, in the fact of in the light of that after considering all this, it was judgment considering. In the light of aforesaid legal position, in the case of petitioner may now be examined. For the evident come in the ambit of one time measure, the explained three condition would have to be mentioned. So for the 1 and 3 is concerned, if there is no dispute, right to the claim made by 10 years were having required. Paragraph 19, what is the court question is there? While petitioner contended that they are working against the making court, exponent 4 would contend that they are not so working. In fact, there is only the vacancy post that is considered by the court. That is, and court opinion. What is court opinion? And the same as the date of against the 20 petitioner, but it is admitted position that petitioner are being paid monthly salary in the pay scale of Jugale, and in the case of petitioner by 11, which they have shown in the pay scale of Assistant Blacksmith with a great pay and annual increment. Question for consideration is whether payment of salary and pay scale of Jugali and Assistant for years together would be possible in absence of section vacancies. In the perusal proposal submitted by the respondent 4 as far back as 4/11/2009, giving detailed sanction posts in the established, that is page 148. Page 148. That is as for the sanction post of the number of post sanction indicator of assembly was shown, and one number of the post sanction indicator can mechanical education as 22, total 20, all shown as fill up. These posts are being held by the petitioner, and accordingly those have been fill up, and these posts are being accordingly those have been shown as fill up. In the remark column, in the mention, these posts were by creation of 1980 as against the 20, the worker was shown engaged doing fixed pay. As a matter of fact, the statement was also annexed to the proposal showing the names of all petitioners holding the said vacant post with pay scale and annual increment. Therefore, there is no question of misconception and misconception of facts or misconception of law.
Yeah.
And next paragraph, Lordship will find. Therefore, despite of potential are given by respondent 4, to the contrary of it is quite evident the petitioner are being paid the pay scale of Jugali and Blacksmith, which is clear indication of the fact that they are working again and valid sanction post. In the course of hearing, the learned counsel of petitioner has also placed before the court details of sanction post in the established as 4, 2013-14, prepared by the respondent 4, which is discussed 22 posts of mechanical helper. Petitioner 1 post of Blacksmith. Respondent 4 has prepared the statement showing the particulars of the petitioner day pay scale shown by the including pay. Therefore, the above is a clear indication of fact that petitioner working against sanction post, carrying the definite pay scale with a pay of annual increment. Moreover, as the case of Nihal Singh, regulation service of petitioner would not carry any additional burden to the
All right.
state. In the light of above, the considering the material on record, an unhesitant view the petitioner have make it a case of regulation. Therefore, the code have considers all things. There is no misconception of law. There is no misconception of fact, and therefore that this is not even applicable to the present event. And my summing up that my submission is that this is a well-written judgment, and the petitioner has failed to show any error apparent of the law, and the ground taken is not even tenable in the review application, and the subsequent judgment and which they want sought to be placed before the is not at all. We can look at the subsequent in view of the effects of when the subsequent event and subsequent cannot be done for or review. Therefore, my humble submission over there is review should fail to make a case of the review and liable to dismiss.
Just a
Okay.
small reply.
Hmm.
CPC খন দিব না CPC খন দিব
No, the only question we are required to do is what is the scope of review
Yes.
in this matter?
To that
So the
point
scope
only.
of review is limited.
Yes, to that point only, Lordship, I will address you about. CPC খন দিয়ক না CPC.
Yes.
Order 47, Lord. Review.
Yes.
One, Lordship, application for review of judgment.
Hmm.
Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, B, by a decree or order from which no appeal is allowed, or C, by a decision on a reference from a court of small causes, and who, from the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within his knowledge or could not be produced by him at the time when the decree was passed or order made. I will pause here, Lordship. All these judgment I placed, Lordship, is your all prior to the passing of the impugned judgment, Lord, which could not be placed at the time of hearing of the case, Lordship. Secondly, Lordship, or on account of some mistake or error apparent on the face of the record, Lordship, page 58 to page 63. All these engagement letters are clear in terms, Lordship, that none of the petitioners were engaged any substantive vacancies. All of them were engaged against works as vacancies.
No, see, first thing you have to go back to the date of filing the review.
Yes.
You have filed it admittedly after 15 or 16 years.
Not 16 years, no.
Ah,
It is
so
around
only
7 years.
Sorry. 7 years?
7.
7 years. Now, your explanation for the delay is that you had interpreted it in a particular manner.
Yeah, our understanding was different.
And accordingly, you have proceeded.
We passed on speaking order also.
Now, if that be so, then from your argument, it appears that you were not aggrieved with the order.
Yeah.
In the manner which it was passed.
Yes.
Till it came to be put to you that perhaps this is not the direction of the court, isn't it?
Yeah.
So, you argued the matter, court passed a particular order, according to you had proceeded to comply the order. Until, according to the petitioner, the respondent, it has not been complied, therefore contempt, because according to them, the interpretation of order cannot be made in a manner that you are seeking to interpret. Leaving aside judgment, just keeping ourselves restricted to Order 47. Where is the error?
I'm again, Lordship, reiterating
No.
page 58
No,
to
no.
63.
If we accept your view,
Lordship,
if this review petition could have been filed immediately
Lordship,
before you had passed whatever orders you had passed,
Lordship.
then perhaps the argument you are making may be open.
No, Lordship will appreciate.
You have already executed, understanding, yes, this is how the court directed us. Right, wrong, whatever it may be.
Lordship will appreciate. To our understanding, Lordship, this was not in one mandamus. It was a direction for the authority to consider.
Correct.
So
Whatever
we
it
considered.
was. Whatever it was.
But once the court pointed out that it's in fact a mandamus, then we again examine the judgment, Lordship.
Therefore, the normal process would be to go and appeal instead of filing a review.
Lordship.
Because now you, according to you, this is not the interpretation, that is the interpretation, which according to you is not made out from the order.
Lordship.
Therefore, it calls for a appeal. This interpretation which you are making and the interpretation you have been asked to make
Yeah.
is not based on deficiency of materials before the court at the time when the judgment was passed. Court examined the matter, passed an order.
Yeah.
You accepted the order.
Yeah.
In a manner you thought the direction was there. And you executed it.
Lord.
They filed a contempt saying, no, this is not the direction. That is the direction.
Yes.
This calls for an interpretation.
At that point of time only, Lordship, we re-examined the
Therefore,
judgment, Lordship.
Therefore, the consequential
Yes.
step should have been to file an appeal.
But it was too late at that point of time, Lord.
So we'll facilitate now
Lordship.
so that you can go and file an appeal.
That is possible. If that liberty is given, Lordship, then granting.
This is just a passing thought. We have not concluded.
Lord.
What we are saying is the gamut of the, arguments that you have made.
Lord. Lordship, in fact, Lordship.
First concentric circle to enter would be error apparent.
Yes. Lordship, in fact, the ground taken in the speaking order, Lordship, are the grounds in the review petition, Lord. That is, your Lordship will appreciate.
All right.
The same grounds I have taken in the review petition. First,
Alright.
their appointments were not against substantive force.
So you may proceed. Order 47 you wanted. to
Yeah.
point.
That is the first, Lordship. First, all those judgments could not be placed at the time of hearing of the matter, Lordship. Secondly, Lordship, error apparent. Error apparent, I have from page 58 to page 63. All these engagement letters, Lordship. Quite clear from these orders, Lordship, that their appointments were never against any substantive post. In fact, those posts were works or sport. Lordship, at page 148, Lordship, one sanction order has been cited, Lordship.
148.
Yes. Sanction post detail works as establishment. This here it is shown at serial number 2 and 3. Assistant blacksmith, one post means works as establishment. Mechanical helper, Jugali 2222. These are the petitioners, Lordship. It was signed by the executive engineer in the year 2009. Now, Lordship, if Lordship comes to the Assam financial rule, Lordship. Now, Lordship, works as establishment is a completely different establishment, Lordship.
These were before the court. These documents were before the court.
Yes. In fact, this was also an apparent error, Lordship. That is what I am trying to point out. Assam financial rule. Now, Lordship, here, Worksers establishment is a completely separate establishment, separate from other establishment. Here, Lordship, one provision is there, 327. Executive engineer may sanction the entertainment of works establishment on receipt of orders from competent authority for the commencement of any work subject to condition that provisions exist in the sanction estimate to cover the cost of such establishment. So sanction is required even for works as establishment from the executive engineer. Merely because it was an sanction by the executive engineer, it doesn't mean that these posts are substantive posts. So that is another apparent error, Lordship. Section 323 to 327, this is the works as establishment under Assam Financial Rules, Lordship. It clearly states, Lordship, the requirement of sanction by the executive engineer.
Assam financial rules.
Yes, Lordship. Assam Financial Rules, I'm at rule 327, which clearly states that even for works as establishment, sanction from the executive engineer is required. And this page 148 only reflects the sanction of the executive engineer for creation of works as establishment, not regular establishment. Lordship, on this point only, Lordship, I would like to 3 lines from the Jiten Kolda judgment, Lordship, that is not before your Lordship.
Yes.
Lordship, just 3 lines.
Paragraph.
This is paragraph 2 of Jiten Kolda judgment, Lordship. This is 2006 2 GLT 654. 2006 2 GLT 654. Paragraph 2, just one small portion I am reading, Lordship. Also, in such engineering and works related departments of the state, there is an other category of workers whose tenure of service and pay and allowances are sourced to a particular ongoing work. Such employees are commonly known as work surge employees. So this is financial rules, Lordship. So if your engagement is against work surge establishment, you can never be said to be an employee of regular establishment. That is law, Lordship, financial rule. These rules also clearly specifies, Lordship, what is the payment to be made. Lordship, Rule 29(1), pay and increment.
Of the same rules.
Same rule. 329(1), pay and increment. 329(1). The members of the work surge establishment are entitled to pay according to the prescribed rates sanctioned from time to time. All cases of advance increment shall be referred to Chief Engineer of Assam. So their pay scale is also given in terms of section Rule 329(1) only, including increment.
But again, coming to the outcome of Umadevi.
Yes, Lord.
Umadevi judgment has given the sum and substance and subsequent judgments after that, including ML Keshari and all that, is that where there is a huge number of irregular appointees, not illegal. Then some scheme or step may be taken by the government for regularization.
Lord.
Now, there is no material to suggest that they are illegal employees. Either before the court then or before this court now. There is no material.
No, Lordship, we are not saying that they cannot be considered for regularization.
Correct.
What we are saying that they do not fulfill the conditions in the of paragraph 53 Umadevi judgment plus the 2013 judgment. That is what I am submitting, Lord.
No. So, if they are considered to be irregular, there is no definition of what is illegal and irregular. Illegal is plain and simple illegal. Maybe there is no appointment.
Illegal means without fulfilling without having any advertisement, recruitment, etc.
So what is irregular?
Irregular means they are fulfilling these 3 conditions, but they are irregularly appointed, Lord.
How?
They fulfill these conditions. The judgments are there, Lord.
So, but what we want to say is, it is not your case that these are illegal appointments.
That is not our case, Lord.
So therefore, it has to be within the ambit of irregular.
Yes.
So they are irregular appointees.
Yes.
Now, if they are irregular appointees, what is so wrong in a court directing the respondent to take steps to regularize their appointment?
That is my understanding also. If court would have directed, you take steps.
No,
and
not
the
consider.
irregular.
Court has directed you to send a proposal.
Yes. But for that, you have to fulfill the criteria, 3 criteria, Lordship. That is the only question. Where is the substantive post, Lordship? And that is what I am trying to repeatedly show your Lordship, their engagement letter.
What is the definition of irregular and illegal?
Lordship, in case of irregular, Lordship, other conditions are there. They fulfill, suppose they have the requisite qualification, there is a post, but some recruitment criteria was not followed. No advertisement was. In some cases, Lordship, this is irregular. In case of Lordship illegal, even no post, no recruitment, nothing else. No education qualification, nothing else.
So therefore, in essence, what you are saying is out of these three criteria, if they fulfill one or two, it can be irregular.
Yes.
So what are the criteria here? That regular vacancy.
More than 10 years,
More than 10 years,
having
regular
a
vacancy.
substantive post, and
Ah.
having the requisite qualification without any continuing, without any intervention of the
Intervention. So there is no intervention of the
Lordship.
court.
In this case, Lordship, two grounds were taken. Their appointments were subsequent to 1996, plus they are not holding substantive post. So that is that. From advertisement, from the engagement orders itself, Lordship, it is clear that they are not engaged against it.
What we are saying. So sum and substance is you have not concluded. Your case before the the coordinate bench is that they are not they are not illegal appointees. You are not saying that they are illegal appointees.
Yes, Lordship. That is why their cases
So
were
if they're
considered.
if they're not illegal appointees, they have to be irregular appointees.
Yes, irregular.
Now, if they're irregular appointees, where is the fault in the court saying that you send a proposal because they're irregular? It is not your case that they're illegal. If it was illegal,
Lordship,
then
to that extent, Lordship, we are not having any problem. We can send proposal, the authority will take a decision. But if it is taken as a mandamus, Lordship, at that point, our problem arises. If it is mandamus.
your direction is to send a proposal. I think the
Then
penalty,
Lordship will clarify that simply.
penultimate
Yes.
to
If-
submit a proposal before
If
finance.
Lordship clarifies that, Lordship, our problem ends at that point of time. The
What is
moment it is regarded as a mandamus, Lordship, our problem arises. That is the only.
No. It is a mandamus to you, the PWD,
Yes.
to submit that proposal.
And finance department will take a decision.
Finance department will do whatever it wants.
They
to
may
do.
reject also.
They may reject also.
I have no problem. Lord.
The direction is to whom, Mr. Borwa?
Hey, that the judgment is clear. Lordship, we cannot interpret the judgment. It is a clear judgment.
In the writ petition.
Lordship, fine.
Even what has fallen
In
from
the
your
writ
Lordship,
petition,
that is our understanding also.
in the writ petition, the finance is not a party.
Therefore, the dispute Lordship, paragraph 21, Lordship will find.
No, first
Paragraph 20 or
first,
judgment.
first come to the post title. Finance is not a party, only PWD.
So no mandamus can be issued against finance. That is our ground in your review petition also.
No, subsequently.
No, but are you appearing for the finance or PWD?
This is a petition filed by the PWD.
Why are you concerned about finance?
They are
Content of
not
finance
even a
is
party,
there.
Lordship. So they cannot be compelled. Lordship.
See, you may represent finance, you may represent PWD, but concern of finance can only be urged by finance, not by PWD.
That is true.
The paragraph 21, Lordship, he did what is the mandamus or all these things. But the paragraph 21 is very much clear. The receipt of
may not- the term
therefore,
mandamus-
we have duty to be told to propose
The term mandamus may not be there, but in
Okay.
effect it is a
Lordship,
mandamus.
yeah, we filed an application under 226. With direction.
It's in the nature of a mandamus.
Yeah, and ordered account limit, what is that is we are the law.
Right, but
In
the-
every case, Lordship not required to say that I have issued the mandamus. Any order direction of the court is made under 26 is a mandamus.
Mandamus or order or direction in the nature of a mandamus. Now the question is to whom?
Yeah, right.
Paragraph 9 or
Paragraph 9 is there.
it to discuss for is not party finance.
Paragraph 7, Lordship will find.
No, finance is not party to discuss for.
That is discussed in the respondent 7 has filed affidavit taken in the affidavit. The finance department of the that is also discussed in the judgment. The finance department necessary party.
Was it made
in
a
absence of
party?
finance department, no relief can be granted to the petitioner. While admitting the petitioner when they engage the master.
Finance was not made a
After
party.
filing this affidavit, another affidavit is filed. Respondent for when again stated that without the concurrence of the finance department has no authority to regulate the petition. It is stated that only for the purpose of payment of salary to the petitioner. It has been shown that petitioner working in the sanction for them against. That finance, that party is also taken care of the judgment.
No, but is finance
The
party?
finance department.
No, is it a party?
No, we have not, that is discussed.
No, no, discussion is okay. So if it is not a party,
In contempt, we have made it a party in the
you
contempt.
may have, but the direction is not against finance.
But contempt, here is the contempt is a different aspect.
We are not
And
dealing with the contempt.
Divine is a review is different.
Hmm.
Here,
All right, we have heard. Let us. We'll keep it for orders on on 18th. We'll keep it for orders on 20. 20.
20 lot on 21st lot.
21st. Then we keep it on 18th.
18 lot I'll be at 18, 19 I'll be at.
All right, then 25th.
Lot.
Keep it for orders on 25th. You examine the papers and tell us. See, parties are arrayed. Directions issued have to be to the party. If it is not, if it is considered to be a direction in respect of someone who's not arrayed a party, then that affected party is entitled to file a review or get some opportunity to place their case. Here is a case, admittedly, finance is not a party. Now the question is whether para 21 can be construed to be a mandamus prima facie. Yes, it is a mandamus or in the nature of a mandamus. But against whom? Against the respondents.
I'll clarify that. At of 21, I will clarify.
Hard. Another counsel to the parties.
Because the parent department is PW, I will clarify.
Matter has been heard at length for further hearing on 25th.
Lot.
25th of March.
Obliged.
We'll try to deliver the order on that day. এখন খালি লওয়াই দিই। আৰু সেই filing Yes.
Your Lordship, this is the matter. The four petitioners here in your Lordship are working as contingent employee in ONGC, your Lordship. There is a standing order, ONGC standing order 1962, which has been enacted pursuant to the power given an industrial employment standing order 1946. Your Lordship. So I am claiming regulation because under provisions are that continue if you are working for more than 180 days, you are entitled for regularization. And these people are working since 2006 onward. People are 2008 also. So have been continuously working in ONGC in different capacity.
You are working under some contractor.
No, I'm not. That is the issue. They are saying it's a contract. I am not. It's not a contract. I'll show because this because the argument has to be divided into several parts. Your Lordship. I'll deal with differently. Your Lordship. On the contract level evaluation, all these things I'll do separately. How it is not a contract at all. Your Lordship. Now, what has happened, Your Lordship? My learned, the respondent has raised 3 objections.
What are you putting to challenge here?
Yeah, Your Lordship, I want regulation service, Your Lordship, in terms of the standing order 2022, Your Lordship. That prayers are here. Your Lordship.
This will.
Yes, Your Lordship.
Should you have not gone before the labor court?
Yes, that's the case. It's not necessary. Your
Section
Lordship.
10, my lord.
Section 10 is not. I am not raising an industrial dispute here. Here, I am claiming regulation on the part of standing order, Your Lordship. I did not go to labor court, Your Lordship. Your Lordship, here, they not necessarily go to labor court because I am claiming regulation in terms of standing order, Your Lordship.
This is. Well, How is it not an industrial dispute?
Your Lordship, I'll show from the act itself. Your Lordship, see the act, Your Lordship.
Industrial dispute act.
Yes, Your Lordship. So standing order, I'm just showing you, Your Lordship. Standing order is the annexed order. Phase, it starts from phase.
Industrial.
That will come to it. Your Lordship, see page 59, Your Lordship. Paper book. Page 59.
59.
Yes, Your Lordship.
Yes.
Here it says this order shall come into so and so, Your Lordship. 2 is classification of workmen. The contingent employees of the commission shall adhere classified as temporary, casual. My Lord has got it. Page 59.
Yes.
A workman who has been under roles of the commission for and who is not less than, it should be 180 days, Your Lordship, not 120, of attendance in any period of 12 consecutive months and shall be a temporary workman, provided a temporary working who has put in not less than 240 days and who possesses the minimum qualification prescribed by the commission and may be considered for conversion as a regular employee, Your Lordship. Then, Your Lordship, here the control and everything is there, Your Lordship, under this thing. This is the, then Your Lordship, page 66, termination of, Your Lordship, this is the provision, Your Lordship, by which I am seeking regulation, Your Lordship. Now, if Your Lordship will see, because they are raising an objection that I am a contract labor, Your Lordship. I am saying it's not a contract labor. Because the question is, they don't have a license contract because under the Contract Labor Abolition Act, Your Lordship, under the Contract Labor Abolition Act, there are certain specifications are there, which has not been complied with. And
No. First, show us the standing order which is violated.
yes, two. I am claiming under 2, Your Lordship. 2. Page 59, Your Lordship. Page 59, Your Lordship. I am claiming regulation on this section 2.
All right, this is your claim.
Yes, sir.
How do you say that this is an except under, what is this, section 10, is it?
Yes, my lord, industrial district, my lord.
Section 10.
Section 10, my lord, in case, my lord, dispute raised, then the my lord, appropriate comment, my lord, shall forward, my lord, it is like this, my lord, where appropriate government is of the opinion that any industrial dispute exists or is apprehended, it may at any time, by order in writing, refer the dispute to a board for promoting the settlement thereof, or refer any matter appearing to be connected with relate to the dispute to a court of inquiry, or refer the dispute or any matter appearing to be connected with or relevant to the dispute, if it relates to any matter specified in the second schedule, to a labor court for adjudication, refer the dispute or any matter appearing to be connected with or relevant to the dispute, whether it refers to any matter specified in the second schedule or the third schedule, to a tribunal for adjudication.
Now?
My lord, yes, and 1A is also, 10(1)A is also there, my lord. And 10(2) also, my lord.
See, if you come to schedule 2.
Yes, Your Lordship.
Second schedule.
My lord.
Yes, Your Lordship.
If you see number 2,
Yes.
matters within the jurisdiction of labor court. Number 2,
Right.
application and interpretation of standing order.
Right. Yes, that is covered.
So you are asking for implementation of the standing order.
Yes, Your Lordship.
So whether it would not fall within the application and interpretation of standing orders,
Your Lordship,
accepted under the required to be referred before a labor court.
Your Lordship is not necessary because when the documents are clearly and explicit here, on the documents, Your Lordship, they need not go to labor court. Your 226, Your Lordship can do it, Your Lordship.
No.
Because what has happened, Your Lordship, this
But
time.
it will be a matter of evidence.
Yes.
No
you have
evidence.
to-
No
you have
evidence. If the documents are there on record, Your Lordship. Documents are there on record. Your
Documents
Lordship.
are there, but it will have to be proved in evidence, the
Your
original
Lordship,
document.
If there is documentary evidence on record, that is They have not disputed any of the documents of us.
All documents.
Your Lordship, documents have not been disputed. Document, that is their document. I am relying on their documents, Your Lordship, not my documents.
No, but whether you are entitled to the benefit under the standing orders,
Yes, Your Lordship. Here
somebody
the
has to return a
document,
finding.
document is spelled out, Your Lordship.
Is
That-
something which requires some
No, Your Lordship, documents.
examination.
No, it doesn't. Your Lordship, the documents from the documents is apparent, Your Lordship.
How can that be from
So,
the
Your Lordship, the
documents?
documents are there. If I take Your Lordship, the documents, it will be clear, Your Lordship. I am direct employees of them, Your Lordship. They have their attendance, everything has been recorded by them, Your Lordship. The
Where is your appointment order? Engagement order?
engagement order is not there yet now. It's very old. But they have engagement, the first engagement order is not there, Your Lordship. But it is, Your Lordship will see,
Where is the engagement order?
Your Lordship will see. If Your Lordship will see here, if Your Lordship will see page 160, Your Lordship, that's what they are given by this is page 160. Annexure P10, Your Lordship. So and so has been working in ONGC Assam ASH if required on recording call. Individual was working in office coordinator come DTP operation section OBC Assam ASH. He is having 2 years and 3 months experience typing without various field objects. He has been working in the office maintenance coordinator and various office. Individuals having interpreted so and so. Yes. So then next is if Your Lordship, they are sending for training also.
This is a certificate, my lord. This is not the, my lord, appointment order, my lord.
This
Not the
is
appointment order.
appointment order. Actually, they have been appointed that way, Your Lordship. There's
Therefore, it is necessary for a proper court to find out your
So
claim.
they have admitted, Your Lordship.
Leaving evidence.
Your Lordship, they have admitted that because if Your Lordship will see everything is attendance, everything is annexed, Your Lordship. Attendance register are there. They are maintaining attendance register. Everything I have been working there. I have been working there, and they have not disputed that I am not working there, Your Lordship. Affidavit is
You'll have to first show us that by way of any authority
yes, Your Lordship.
that notwithstanding section 10,
Yes, sir.
these matters can be handled by in the manner that you are seeking orders from me.
Yes, sir. There's no bar under 226, Your Lordship. 226, you can go through it because it's a
There is no bar.
yes, sir.
But you see,
There is no bar under 226, Your Lordship.
there
but
is no
226
bar. But then what are your prayers essentially?
Yes, sir. Prayers are, if Your Lordship see.
Directing them to regularize.
Yes, sir. That regulation, Your Lordship.
In invoking powers under standing order 2 of the standing order so and so.
Yes, sir.
Then whether you are covered by the standing orders or not,
Because if they are saying I'm contingent, Your Lordship, their document is showing. Because what they are trying to show that they have to bring a concept of contractor in between. By show they want to show that but contractor is not there, Your Lordship. Then they go to say fairness policy. Fairness policy, I'm not covered by that because fairness policy has come into because they have relied on Your Lordship a judgment of
see, do you expect the court, how many petitioners are here?
4.
4 petitioners.
Yes, Your Lordship.
So do you expect the court to go through whether how many 180 days or 30 days they work, attendance is there?
No, it is there. All documents are there. Their documents. Their documents are there, Your Lordship. And they have not denied it also. Because when I said they have their affidavit doesn't deny that I am in continuous service of there. They have not denied it. They are saying only I am under a contractor. That's only their statement. They are not saying that I am not working there.
So therefore,
Your Lordship.
originally you'll have to produce your appointment orders, how you are
No, the
appointed.
question here, Your Lordship have to see also whether contractors are there or not. Contractors are not there, Your
All
Lordship.
right, we'll accept your submission that there
Yes.
are no contractors.
Yes, Your Lordship.
But you'll have to show us how you are employed
Directly
in
because
service.
because they have been they have been working because if Your Lordship will see all the documents are there.
How no, how
Here I have attendance sheet. They are giving GPF. They are APF. They are paying.
whatever it may be, but how can you claim to be, see, Umar Devi is applicable to all public sectors also,
Yes,
state
sir.
as well as public sector.
Yes, Your Lordship.
So now you are claiming regularization for the services.
Yes, Your Lordship.
You'll have to first show that your entry into the into this particular job is not illegal.
They are not saying that I have entered illegal. That affidavit doesn't say so.
No, but forget about them.
No,
You'll
Your
have to
Lordship-
you'll have to show us how your service,
Yes.
how you had entered into the service.
I have entered
Some order has to be there.
because they used to recruit like that, Your Lordship, or ONGC used to, people used to recruit like that.
Therefore, the necessity of having proper evidence.
No, Your Lordship, they have not said they have not recruited me. They have not said anything like that.
My lord, just for a moment, my lord, I am, what has been fallen from your lordship, my lord. This is the judgment 2023-1, SCC, my lord, 463. This is the, what has been fallen from your lordship. Because I want, while making this submission by my learned senior friend, my lord, then I thought this is proper to place it, my lord, because these are also contract labors. My lord, they appeared before the para 2.3, my lord, before the labor code first. Labor code said, para 2.3, my lord. Labor code initially said they are under the, they held that they are under the contractor. And while on appeal before the central labor court, my lord, then the central labor court said, no, you are the under the direct engagement of the principal employer. Now, my lord, para 5, my lord. On going to the entire materials on record, no documentary evidence was produced by which it can be said that the contesting respondents were the employees of the appellant. There is no provision under Section 10 of the Contract Labor Regulation Act that the worker employees employed by the contractor automatically become the employee of the appellant, and or the appellant of the contractor shall be entitled for automatic absorption, and or they become the employees of the principal employer. It is to be noted that even the direct control and the supervision of the contesting respondents.
So that is only merit.
Yes,
What
yes,
we
correct,
want
my
to
lord, yes.
show is
Now, my lord, exactly on the point, my lord, para 12, 13, 15, my lord, exactly on the point. Here also, my lord, debarring those kind of appointment, there is no prohibiting notification has been issued. Now, para 13, my lord, in reference to International Airport Authority, that decision, my lord. After considering the decision of this court, SAIL versus National Union Waterfront workers, it has been observed that and held by this court that where there is no abolition of contract labor under Section 10 of the Contract Labor Regulation and Abolition Act, but the contract labor contains that contract between the principal employer and the contractor same or nominal, the remedy is purely under the ID Act, under Section 10. It is further observed that the industrial adjudicator can grant relief sought if it finds that the contract between the principal employer and the contractor is same. Whether the contract is same or otherwise, my lord, that will be decided by the labor court, my lord. Nominally or merely a camouflage to employment, deny employment benefits to the employee, and there is in fact a direct employment by applying these states.
Mr. Chaudhary, there are
everything.
you'll have to give us some authorities to.
No, here Your Lordship, I'll show it because what happens here, they have presumed that it's a contract labor. It's not their judgment to that effect, Your Lordship. From that ONGC that it has held by this honorable court also. This contractor concept is a camouflage and they don't have any document.
No,
Three judgments.
See, the basis of your claim
Yes, Your Lordship.
is that you are direct employees of the corporation.
Yes, Your Lordship.
You have been working.
Yes, Your Lordship.
You also admit that there is no specific appointment order.
Yeah, I don't have it.
You don't have.
I don't
That's
have
right.
it. Your Lordship. They may be
But you have been engaged on whatever
We have been
period of
working-
service. Now, whether in these circumstances it would be sufficient
Yes, Your Lordship.
to for you
Your Lordship will
or
give me
to
some time.
entertain your.
I'll try to get the appointment letter if they are having it. Your Lordship.
All right.
Trying to get appointment letter.
You get it and tell us and
I'll
show
get
us.
Your Lordship. Appointment letter
Show us.
because I'll ask them.
Otherwise, my lord, that para 34, 35, 36, my lord, they accept, my lord, admit, my lord.
Because
they were
that is
enjoined
why
to be
in these
No, no, you have
matters,
not admitted. There's no admission.
see,
No, no.
writ court is to decide matters which are where there is no disputed questions of fact.
Right.
Here, the very dispute is that according to them, you are not regular employees employed under.
But the question is if the documents are showing you that there
No, but it has to be on the
no,
basis
your
of
lordship under 226 also your lordship can decide disputed question of fact also.
we
that
cannot
there is different-
we would not like to decide on
and
this
then
issue.
if the documents are there, the documents are supporting that, then it can be done, your lordship.
You show us some authorities on
Yes,
this.
I'll
When do you want it?
I will have to give you.
After one? 1 week, 2 weeks?
Your lordship,
You give us your date when you want it. We'll
Lordship.
fix it.
I want to consult in the month of-
Heard Mr. P. Chaudhary, Learned Counsel. For the petitioner, Mr. P.K. Das, Learned. Counsel representing the ONGC authority.
10th April, your lordship.
Uh,
10th April.
in order to enable the counsel for the petitioner to please.
अच्छा, ठीक है सर my that is some problem I guess. Then I'll pick it sometime.
You want it on 10?
No, but he has some problem.
No problem.
10th of April.
Yes, sir.
10th
It is
of
just prior to Bihu, that is why I say, it is just prior to Bihu, my
No,
lord.
if he has some problem, I can postpone it. There's no problem, your lordship.
He has no problems.
My lord, I'll be there,
You will have to fix your date
Yes.
because you are coming from.
out station.
Deeply,
Deeply
Let the
obliged,
matter be
obliged.
listed on 10th of April.
I'm highly.
Yes.
May I please, your lord?
Pleadings are completed? Pleadings completed?
Not completed, lord.
Yes.
This is a case, lordship. It relates to compensation allowance. Relates to compensation allowance, lordship. And what is compensation allowance, lordship? A person may have to work for more than 20 years in a service, and he may be removed, suspended, or discharged from service. Then he is entitled for this compensation allowance. An administrative petitioner was appointed on 30/10/1990, lordship, as a sepoy of Gion, lordship, in LIC department. Lordship.
What is your prayer now?
There is, lordship, I'm entitled for compensation allowance, lordship.
That has been rejected by the High Court, single bench, division bench,
No,
SFE.
lordship, no, lordship.
What
That is
was
different.
dismissed there?
Their cause of action is different, lordship.
What was the?
That writ petition was filed after my removal, lordship. That writ petition was dismissed. Therefore, the writ appeal was preferred. That was dismissed, and therefore SLP
What
was
were you challenging there?
challenging, lordship. I'm only for compensation allowance, lordship. Lordship, may I
No, in those
fix it,
petitions.
lordship. I'm
in-
filing affidavit regarding this.
What have you
lordship.
challenged in those writ petitions? Earlier
The
writ
removal
petitions?
Service, lordship. I was removed from service. That I have challenged, lordship, earlier. But cause of action is different in this case, lordship. Completely different case, lordship.
Your representation has been rejected. Here?
Yeah, lordship, I am pending, still pending, lordship.
Then
Representation is still pending. Lordship, may I kindly say,
why have you passed any order on the representation?
Rejected. Prayer is.
Huh?
His prayer has been rejected.
Have you served him a copy?
no, lordship. I do not have any copy, lordship.
We have filed our affidavit here also.
Hmm?
We have filed our affidavit also denying the compassionate allowance.
Where is that? Page number?
My lord, kindly consider my affidavit. Rule is also there. His actual prayer is under a rule. Provision.
He has filed a representation. Have you passed an order?
Representation, my lord, I have not.
You have
They are
not seen?
dated for this.
Representation has
Where is your representation?
page 31 and 32, lordship. Of my petition, lord. 31, 32.
31 and 32.
32, lordship.
Yes. Now, this representation, what orders have you passed? Not there?
Oh, wait.
You serve him a copy. Is it rejected?
No, not rejected, my lord. Here, the representation has not been considered.
Huh?
For compassionate appointment, what is it?
Allowance.
Allowance.
30, 31, 32.
31, 32.
31, 30.
Let me see,
31, 30. Lordship, regarding salient features of compensation allowance, I filed an affidavit, Lordship. It's in the records, Lordship. Kindly see the affidavit, Lordship. At page 8, Lordship. My affidavit, Lordship. Last paragraph, Lordship.
Affidavit in reply.
Not reply, Lordship. Additional affidavit, Lordship. There is additional affidavit. It is in the record, Lordship.
Mr. Counsel for LIC, you
Not
don't have the
reply,
instruction.
reply not given.
What reply not given?
Representation or reply from LIC.
Not given.
Not given.
Give it to him.
That may be done.
Dispose it of.
That may be done. We'll consider.
Heard learned counsel for the parties. The petitioner was appointed as a sepoy within bracket peon on 3010/1990 in the LIC department. Stop. He joined service on the said date and had been rendering his services to the under the authority concerned. Stop. On 16/4/2016, he was removed from the post. Stop. This order of removal came to be challenged by the petitioner by filing WPC 7565 of 2016 and by order dated 2012/2017, the High Court dismissed the writ petition. Stop. Aggrieved by the order of dismissal of the writ petition, the petitioner preferred an appeal, being writ appeal number 179 of 2018. Stop. This appeal also came to be dismissed. Stop. During the currency of the proceedings before the court, petitioner had filed a representation on 18/7/2017 for compassionate allowance, which was pending before the competent authorities. Stop. After dismissal of the writ appeal, the petitioner also prepared an SLP before the apex court, being SLP within bracket civil bracket close diary number 31170/2022. Stop. The SLP also came to be dismissed on 7/11/2022. Stop. The apex court refused to interfere with the order passed by the Guwahati High Court. Stop. Whereas the present writ petition has been filed seeking a direction to the respondents to consider his application or representation seeking compassionate allowance, which was filed before the authorities concerned. Stop. A copy of the same is enclosed to the present writ petition at Annexure 4 within bracket page 31. Stop. A similar application was also filed before the Senior Divisional Manager LIC, Silchar Divisional Office on 23/1/2023. Stop. It is the claim of the petitioner that the in spite of the representations being pending, seeking compassionate allowance, no orders were passed by the LIC authorities. Stop. The LIC authorities, being respondents in the present proceedings, have also filed their counter affidavit. Stop. A perusal of the counter affidavit does not reflect any averment as to the status of the representations filed before the LIC authorities stated to be pending before the authority concerned. Stop. Learned counsel for the LIC also submits that he has no instructions as to whether any orders have been passed on these applications. Stop. Since the limited prayer in the present writ petition is a direction to the respondent authorities to release the compassionate allowance in favor of the petitioner, and since the representations have not yet been disposed of, end of rigor, as no instructions has been placed before the court, as no information has been placed before the court by the respondent authorities that these representations has been disposed of, his writ petition stands closed at this stage without entering into upon the merits of the case by issuing a direction to the respondent authorities, more particularly respondent number 1 and 3 to consider the representations filed by the petitioner and thereafter dispose the same by passing a speaking order on the same. If in the meantime any speaking order had been passed, if any order had been passed by the respondents on those representations, copies thereof be served on the writ petitioner. Stop. The direction above be carried out within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition disposed of, no order is proposed.
Obliged.
Oh, someone has filed an adjournment slip.
No, sure. The CKS Bhavan Lordship is not available.
All right. In view of the adjournment request circulated between the parties, matter stands referred to be listed after 2 weeks. 2 weeks?
Could it be on a fixed date, my lord? Could it be on a date fixed, my lord?
So that on a be adjourned to be listed on 8th of April?
8th.
8th of April.
Obliged.
16.
May I please, your lordship. Lordship, the matter may kindly be taken up on 18 Lordship Tuesday.
18 is not possible. Our dockets are filled up. We can give you on 25th.
Obliged.
List on 25th of March as prayed for by the learned counsel for the petitioner. MS A. Bora, IPS for the respondent.
Deeply obliged.